We have a physical quorum.
Ladies and gentlemen, council members, this is Ms. Haley Johnston. And I don't know if you've had the pleasure of meeting her and working with her, but she has served the citizens of Tampa well. I am proud to have met her. I'm proud to have worked with her. She has been the legislative aide for me for how long now? 4 months, 6 months? Since August. But you're part of the family, and I want to thank you for being part of the family. She is a junior at USF. Go Bulls. And again, Ms. Johnston, thank you for everything you've done for my office. Thank you for everything you've done and helped and assist the City Council. Thank you for everything you have done for the citizens of Tampa. And thank you for being part of the family. Today is her last day, and she is leaving to pursue her studies. So this is your moment. Anything you'd like to say?
I just want to say thank you to Tim and you especially. It's been interesting listening to all you guys talk on Thursdays. It's been interesting, fun, hearing all the conversations. So I've appreciated it, and just picking up on the terminology and the words and how you guys speak to each other, and with the public speakers and the audience and all the department heads. I've enjoyed it. So thank you.
You are welcome. Any council members like to say anything?
You're gonna come up and get a photo?
Yes.
Yeah.
Thank you, Ms. Councilwoman Hurtado. Brilliant idea.
Yeah, Tim, you should be in the picture.
Yeah, Tim.
Yeah,
Yeah, Tim.
Yeah. Oh, here, yeah, you can stand by. That's a good point. Wherever you want to be. So we should do go Bulls.
Oh, yeah, it should be Go Bulls. It's the only time we can do that.
How you doing, the Bulls? Okay, all right, go Bulls. All right.
Ready? All right. 1, 2, 3. Very good.
All right.
That's good propaganda right there.
It is Tampa. Thank you, council members, for indulging me in that. Let's see. Mr. Rosner, let's go to agenda item number 18.
Good afternoon, Council, Mr. Chair.
Okay.
That's okay. I just
No,
want to
you're-
introduce it. So Deputy Administrator Elise Strumgo. Rob Rosner will come before you today with an update to the CBA comments that were provided to us at the last meeting. So he'll provide a brief overview, if you like, for us to go through all the comments, and then we'll let Susan close us out.
Thank you. Can we pull up the presentation, please? Next slide, please. I guess I'm doing it, huh? There we go. Good afternoon. Thank you for having me here. We're coming back today with a first reading of the ordinance that you requested, and we took all the comments that you'd made and all the public comments that were made and enclosed those in a memo. And this presentation is going to identify what was different from our first presentation to today's presentation. So these first couple of slides are just going to be review, just to show you that these things are still the same, and we've highlighted in here what's different. So with that, the purpose of this ordinance is to ensure the incorporation of agreed-upon CBA items as part of the community benefits agreement that's approved by City Council, and to also bring transparency to projects before they come out of the ground. It still applies to the same with the P3, and I'm not going to reread this, but this is still the same as last time. It does apply to new construction, redevelopment, renovations, and rehabilitation. So where we heard you is where we changed the thresholds where the minimum amounts are at. So instead of 1, 2, or 2, 4, and 8, we went with 5 million as the beginning, with 20% at 1 million. So if someone receives $1 million on a $5 million project, then that would trigger the CBA. Or if it's an automatic $10 million, that's still the same. So that is the big piece here. And then the one thing is that was asked between, is this only CRA or is this only city? No, it is now combined. That was one of the questions that came up. And we included the language that it's either or, because the incentive could come from either place. So we'll move on. This is still the same. The pre-work is still the same, the developer. So on this chart, this shows the tiers, same thing I showed in the first one, except for it's extended out to tier 1, tier 2, and tier 3. So it's 5 million, 10 million, and 25 million instead of what we had before. And then it caps out between 10 million. We raised it for tier 2 for 20 million, and for tier 3, 30 million. So that moved it all up a little bit so that we can be a fair size. Another thing that was brought up was and I didn't bold it here and I realized I missed that, was on the MBE, SLBE requirements, that in working with our EBO department about the ordinance that's already in place for that, that there's a minimum requirement of 15%. And then we put stretch goals on here. So each one of these says 15 to 20, 15 to 25, or 15 to 30, depending on, in that order from tier 1 through tier 3. So in order to be compliant with that ordinance, that's why there's two numbers on there. One is the minimum goal and one's the stretch goal. Other than that, everything else is still the same on this matrix. And this is taking it and applying it to a project that we did. So if Rome Yard came to us when it was not an RFP, but if they were to come to us, we were valuing the 18 acres at about $1.5 million an acre in 2020. And so that would give us around over $27 million project. So that would have fit cleanly into tier 2. So that's how this is highlighted here to show you how that would get applied. So when they come to us and say, hey, we need your acreage, we want it for free, or we want it for $1 an acre or something, we'd say, well, their difference is 27 million, you would fit in tier 2. So this is just applying it and giving you an example of how it would be applied. This is still the same slide, and I highlighted at the bottom is that if it's located in a CRA district, that CRA CAC members would be eligible. And I just wanted to make sure that you saw that we are trying to incorporate both together. Moving on. This is still the same. The process hadn't changed except for who gets involved. And then our next recommendations is the approval of first reading today, and then proceeding with a second reading, I would guess, on the 5th, but I think that's a legislative issue. So with that, I'm take any questions you have.
You got Councilman Goods.
Well, we've come back to what we can't do to what we can do.
Yes, sir.
As you remember, back in 2019, we were told we couldn't do this, but only we in the CRA. And other people did it, so I guess we kind of was right from the get-go that we could do it. So I'm glad that Ms. Travis came along and your office to get it done, and for the whole city, because it needs to be done. I'm glad that I was able to put this on the table, and this council went along with the first time we went with our CRAs. I think it's going to be good for developers as well.
Absolutely.
So I think it's a win-win for all parties, but definitely a win-win for communities to be able to get some things that they might want to see, and you don't get a lot of fussing and fighting about a project that's coming in their community, to where if we're giving some dollars to a project, they'll be able to talk about what they'd like to see and help out with the project if they can. So I think it's a win-win, and glad we've got this done, and hope we'll be able to go ahead and move this forward. Is January 5th the quickest date we get a second reading on
I'll
this?
defer that to Ms. Velez and Ms. Celine. 'Cause
Get an answer on that?
that's the earliest
I'd
one
like-
I think we can do from the next. I'm going to have Ms. Velez.
Like to get it done before Christmas?
So Susan Johnson, Velez Legal Department. So a couple of things. The ordinance that's before you for first reading today does incorporate all of the changes and revisions that we based on council's comments at the workshop, as well as comments from the public. So the clerk usually announces a second reading, but I did want to add that in addition, if council does the first reading today and the date that is set for second reading, we will also present to you the two related resolutions that we presented as part of the package at the October workshop. The first one would be to create the Community Benefits Advisory Council for each project, and describe how that is going to be, those councils are going to be created, and then also approve the form of the community information sheet that the developer in the city would work through together to determine what the benefits are, et cetera.
Ms. Lucas, if we move forward, what would be the earliest for a second reading?
The earliest second read will be January 5th due to publication.
January 5th? All right, January 5th it is. Okay, thank you.
You're welcome. And I'm happy to answer any questions on the ordinance. If council finds it acceptable, we would ask you to proceed with first reading of the ordinance this afternoon.
Any other comments, questions?
Move to approve. Okay,
Better read it. Councilman Goods,
All
you
right.
sound like you want to read this.
You want to read it?
Agenda item number 18.
Number 18, all right. File number E2022-8CH2, ordinance being presented for first reading consideration. Ordinance of the City of Tampa, Florida, relating to the Community Benefits Program, making provisions to the Tampa Code of Ordinance, Chapter 2, Administration, creating Article 11, Section 2-850 through Section 2-856, providing for severability, providing an effective date.
Excuse me, we have a motion made by Councilman Good, seconded by Councilman Maniscalco. So roll call vote, please.
Viera. Yes. Goos.
Yes.
Maniscalco. Yes. Miranda. Yes. Hurtak.
Yes.
Carlson. And Citro.
Yes.
Motion carried unanimously with Carlson being absent at vote. Second reading and adoption will be held on January 5th, 2023 at 9:30 a.m.
Thank you, council members. This is a big deal.
Thank you.
Thank you.
Ladies and gentlemen, and council, I would like to present Ms. Jennifer Cohen. Did I pronounce your last name correctly?
It's actually Callan.
Cowan, thank you. She is with the attorney firm of Bryant, Miller, and Olive, and she is with us today to present items 19 through 23, and to answer any questions that may be addressed by council. So shall we start with agenda item number 19?
Okay. Good afternoon, council. As was just said, BMO was retained
For the record, just please state your name.
Oh, I'm so sorry. I'm Jennifer Cowan with Bryant, Miller, and Olive. BMO was retained for the limited purpose of drafting the ordinances that would reflect the 5 charter revisions that this council put forth. In drafting those, we reviewed the meeting videos, the summaries, as well as the transcripts. In addition, after reviewing all of that, some of the 5 were very clear, and there was no question as to what the council's intent were. There were others that we believe that these capture your intent. There was some question, so I leave it to the council to determine. In creating these ordinances, we did review this both with your city attorney and your city council attorney, and they agreed that these ordinances captured the council's intent. So to the first one, this is the ordinance.
Yes, and I'm waiting for her to lift her head.
Oh,
so
I'm
she-
sorry.
Ms. Cowan,
Just,
Ms. Councilwoman Hurtak, you're recognized.
I just wanted to say that for council, I had my assistant Kelly print out a copy of each ordinance, and I circled the actual relevant information, so while she's talking about it, I will pass them out so everybody gets a chance to actually look at the language.
Okay.
Yeah, I have enough for one of you, yeah. It's generally on the second page, just wanted to, so thank you. I just wanted to get that out of the way first, so we do have copies in front of us.
Okay. And the way that these are structured, Section 1 actually has the charter language in a strike through and underline showing the change, and then Section 2 has the question that will be posed to the electorate. So for the ordinance changing Section 5.01, you'll see that this ordinance was revised to provide for the hiring of legal counsel who is not a city employee to serve as to advise the Citizens Review Board for the Tampa Police Department. That is what the language shows. In addition to that, one other point that was discussed with both the city attorney and the city council attorney is that there is an existing ordinance that deals with this board, and it's codified in Section 18-8 of the city's code, and it provides for legal counsel for the Citizens Review Board. So should this board desire, they could also amend that ordinance to provide for the desired legal counsel that that you want, and that would allow a quicker amendment and potentially at in less time and with less expense than going to referendum. Or you can go forward with the charter amendments that's before you.
Comments or questions?
The only question I have, sir, if I may,
Councilman
It
Miranda.
says provide legal counsel, but it doesn't say what the hourly rate's gonna be. It doesn't say anything about the counselor we're gonna hire, wherever that person may be.
Correct, correct. So,
So you got a blank check, or I don't know what it is.
no, it's just that the city will provide that counsel to the board. Right, this, as it's written, it just says that the city shall provide counsel. So in many other instances, you may have the city that provides counsel on a unique issue. For instance, today, with me standing before you and having drafted these ordinances, this was done under a special counsel agreement that we have with the city.
And I realize that from time to time, the city does hire outside counsel if they have a conflict or something of that nature. But this is just wide open. I don't know. I'm just asking the question.
Councilwoman Hurtak.
I agree with some of the speakers from earlier this morning, because the entire point of this is the city not providing, but the CRB able to retain. And I actually have the language for the other that I asked this to be based on, the Miami City Code, the Orange County Code, and the Key West Charter. And the Miami City Code starts the CIP, because they call it the Citizens, I can't remember the exact name, but they call it the CIP instead. And it says the CIP shall hire an experienced and competent attorney at law. In the Orange County Code, it says the Citizens Review Board is authorized to retain legal counsel. And then Key West Charter says the CRB may retain the services of attorney and, so in following that vein, making sure that it's not the city that's retaining, but the board, to keep it completely autonomous. So I would like to make that change, and I also would like to take out for the Tampa Police Department, because the Citizens Review Board is about the police department, so I don't see a need to have those. But I also would like to take out the language for the police department in the actual amendment, because again, the Citizens Review Board that's what it does already. So those are the changes I would make.
Yes, Councilman Vieira.
Thank you. And yeah, I'm fine with that. I mean, and I like Councilwoman Hurtak. I think you said the second part where it says the CRB is authorized to, so they may do so. And with regards to Councilman Miranda's point, which is very well taken on having it be a blank check. I mean, what this is essentially is giving the CRB, I use the term outside counsel, in every attorney should, by virtue of their being a member of the Florida Bar, be independent and have loyalty and whatnot to their client or clients. But outside counsel for the meetings, which I think it should be pretty narrowly tailored, because the meetings don't run too darn long. The research issues, if any, would be very, very limited. The going government rate, I mean, is probably, I don't want to say a number, probably $200 for something like this, $205, $210, something of that nature. But in other words, I'm fine with those changes. Mm-hmm.
Thank you, and that's actually a really good point, is that we're not hiring a full-time attorney. They don't need they just need someone when they need someone. So yes, yes, thank you for bringing that up.
I'm confused a little bit.
Councilman Goods.
Need someone, I don't know what that means. Are we saying when they meet, they have their attorney?
Yeah.
All right, okay, all right, want to make sure it's clear. If they're meeting, they have their attorney, not, they need an attorney. Okay, all right.
Councilman Maniscalco.
Thank you very much. And I agree with what's been said, specifically Councilman Vieira and the maker or the potential motion that's coming. You know, these meetings happen once a month, so it's not a huge amount of money that's being billed. I don't know what the hourly rate would be, but, you know, the meetings might be over in 2 hours, might be an hour, I don't know. But this would provide for the board to be truly independent, have a truly, there is no perception of a bias, there is no perception of, well, you know, the city chose this attorney. It keeps it separate, it makes it independent. I don't see any harm in this. I think, you know, it helps keep the board as it is intended to be. And that is independent of the opinions of whomever. They choose they retain the attorney. And that's it, so thank you.
Any other questions? And it is not defined, but I'm curious to Councilman Miranda's question. Whose budget is this coming out of? Is this coming out of City Council's budget? Is it coming out of the City of Tampa's budget? And but before, Ms. Selman, you're gonna get up and answer that, but I would like an opinion from the legal representative. There is a clause that we have, and it states that the CRB can ask for an outside independent attorney for a conflict of interest. How does this differ from conflict of interest? And can that conflict of interest, can the attorneys that are on the list that the city has for outside independent attorneys be used for that conflict of interest? Don't we already have that in place now?
I believe would be a more appropriate question for your city attorney.
Thank you then. Ms. Zelman.
Yeah, just to clarify, Andrea Zellman, City Attorney, a couple of things. Let me address one of the more minor issues first. To the people that were asking why the words "for the Tampa Police Department" was in there, the Citizens Review Board Ordinance, Section 18-8 of the City Code, the title is Citizen Review Board for the Tampa Police Department. So that language was just put in to mirror the way the current code reads. There was nothing intended, not intended to mislead anyone. I think the issue we're getting at is, in the city of Tampa, the only entity that can enter into contracts is the city of Tampa. The city council can't independently contract with an attorney, nor can any board, including the Citizens Review Board. So I think what Jennifer and Marty and I discussed this with her, what was trying to be accomplished here was what we thought was council's intent, was simply that the attorney wouldn't be an employee of the city of Tampa, so they'd have that level of independence. They can't truly be independent of the city of Tampa because the city of Tampa has to contract with them, pay them, and they are representing a board of the city of Tampa. Perhaps, a suggestion may be, if what city council is trying to get at is that they want to say in picking the attorney rather than our department picking the attorney, we could, have a process like what you all did with your search for your CRA director, where the body itself, and in this case, I guess it would be the CRB, could interview the attorneys that they're selecting. But again, at the end of the day, it's still going to be a contract with the city of Tampa. And I thought that the key thing the council was trying to accomplish was that it not be an employee of the city of Tampa. My office, the police department, whatever. And then one final comment to Jennifer's point. This could be accomplished by amending Section 18-8 without touching the charter, which, as she said, would be a lot faster, wouldn't require a referendum, wouldn't require a rush to get it on the ballot, just as an aside. But again, I think that's what you're trying to accomplish. And then finally, as to the other ordinances that you mentioned from Orange County and Key West, they have a whole charter provision for their Citizens Review Board. We don't. If you look at some of those other ones, like the Orange County one, it basically says that the panel can select the attorney with the funding to be provided by the county commission. So I mean, at the end of the day, it's still, as it would be here, it's still the city attorney who's hiring or paying or contracting with the attorney. But if you wanted the board to have more say in the selection process, there'd be a way to write that in. Probably better to put it in the ordinance than in the charter, but that's for you all to decide.
Then that goes back to my question. We already have that in place. If
But you
there's a
have it in
conflict
place
of
for
interest,
conflict counsel, correct?
then the board can say, sorry, We don't want you to involve because of this conflict of interest. Now we're gonna go and go outside with the list of attorneys that are already there.
Right, now the way it's currently written, it's the city attorney that has to make that determination. Just to be fair, I think what you're trying to accomplish is you
Is
want the
for
board
the
to
board
make
to
that
say,
determination.
Step aside, we have a conflict here.
No.
I want, that's how I'm reading it.
No.
No,
That's
I
how
think
I'm
what,
reading it as, and that's what I'm trying to get clarification on.
well, that's, currently that only applies to when there is a conflict. I think what Ms. Hurtag is trying to say is what this proposal was intended to address was just full-time. Just full-time, have an outside counsel as the board's attorney, not only in cases of conflict.
Councilwoman Hurtag.
Full-time meaning, thank you, full-time meaning whenever
Every
they're
meeting,
needed,
yeah.
not full-time, but.
Correct.
So would you be, would this language be better? The CRB shall retain legal counsel with funding to be provided by the city, who is not a city employee, to serve as a legal advisor to the Citizens Review Board. So if we added that language, just to clarify, yes, with funding to be provided by the city.
I'm sorry, can you say that again?
The CRB shall retain legal counsel with funding to be provided by the city, who is not a city employee, to serve as the legal advisor to the Citizens Review Board.
Well, but again, retain implies they'd be contracting with that attorney, so, but only the city can contract with the attorney, so I think
Shall
something like
choose?
shall select.
Select,
You know, something.
okay. Select, I'm happy with that word, select. Okay, I will give this, does that,
Councilman Maniscalco.
I mean, if this works, this works. I was gonna suggest if this is not to work, that the CRB nominate an attorney of their choosing that's not a city attorney, and then it comes to city council for final approval, being that they're contracting with the city and the money's coming from us. So there's a level of oversight. I don't know if that's necessary or possible if, this doesn't fly, so.
yeah, that's.
Councilman Vieira.
Thank you very much. And you know, when I served on the, what was it, the Civil Service Review Board, we had an attorney who was an outside attorney. Ours was Delano Stewart, God bless him, who's such a great guy. And it wasn't a full-time job. He probably did it 2, 3, 4 hours a month. And that's kind of what I think a reasonable interpretation of this is. And also remember, again, and I'll leave it to the maker of the motion, that the CRB doesn't necessarily have to do this. It's if they choose to do this. And in terms of the conflict issue, there's two kinds of, there's what I call small C conflict and big C conflict. The big C conflict is if there's a direct conflict of interest that goes on that implicates something that starts a legal, an ethical process. I think what the larger point that people have been making here for a year and a half or 2 years on this issue is that there is, for a board like this, there ought to be an outside counsel who's not a city employee, and I think that's a very reasonable position to take. I've always supported that, et cetera, et cetera. So to answer the chairman's point, Chairman Citro, the point of conflict, this is not what this is addressing. This is addressing the appearance of non-independence. And for a board like this, appearance is something that's very relevant. So that's why I support this as such. Thank you.
Councilwoman Hurtag.
Oh, thank you. I apologize. So I will make a motion to change the language, and I have it for you. For the underlined to be, the CRB shall select legal counsel with funding to be provided by the city, who is not a city employee, to serve as the legal advisor to the Citizens Review Board.
We have a motion made by Councilwoman Hurtak, seconded by Councilman Maniscalco. Is there any further discussion? Mr. Shelby.
Logistically, Council, I just want to be clear on how this is handled so we can put it within the time frame that's necessary to get this to the Supervisor of Elections. And I spoke with the clerk this morning. We also have an issue of publication for second reading. And the date for publication, the way the publications work, is December 21st. Is that correct? That would be the soonest that it could be advertised? Okay.
I will submit it to the publication December
Okay, on December 23rd, it gets published, and then it would come back to council January 5th, because shortly thereafter, I believe it's the cutoff time. It has to be at the supervisor elections, I believe, by the 20th. I'll double check.
Mm-hmm.
It's plenty of time.
Well, it does have to go over to the mayor and the administration as well.
We have a motion made by Councilwoman Hurtak, second by Councilman Maniscalco. Any further discussion? Councilman Carlson. Okay, I thought you were going to put on your light. Okay.
Just one more clarification then, and I guess that would go to you, Ms. Cowan. If these changes are made today to this or any of the other ordinances, when would it then be approved by council for first reading consideration?
This
What's
is the first reading.
This is, I understood this is your first reading.
But there's changes to the language, is that correct? Or this doesn't change the title?
I was told we could make changes
Usually it
between
will.
first and second reading. Yeah, that was the whole point of this, is that some of this we were going to flesh out here between first and second reading.
But if the title, I just want to be absolutely clear, and if that's the understanding, I want to be absolutely clear about this so there's no misunderstanding. If it requires a title change,
So if you change the language to take out for the Tampa Police Department, it will require another first reading because you'll change the title block.
Okay, then we can keep for the Tampa Police Department. That's fine. Or, I'm sorry.
If we do that, then.
Councilman Carlson.
Thank you. If we do that, then because there's been what I consider a lot of misinterpretation of the charter, I think we should clarify somewhere that this this attorney would work with the CRB, not with the police department. We've had, it's an obvious thing, but we had 4 years of settlements signed outside the charter requirement, so you never know what will happen.
Councilman Goose.
I don't understand. I just don't understand. You have a legal department that is here right now. You have a legal department upstairs right now. How many times have we been here and they've made a change and brought the ordinance right back down the same day and we make the corrections the same time? How many times have we done that? So I don't understand this time frame, because if she's making the changes now, by the time we get down to part of the last charter number 23 or whatever, they could have that back to us with that change. Shelby? I'm confused.
that may be true, sir, but in this case, an outside attorney's firm was retained to be able to do this, not the legal department.
But
And-
but excuse me, you
I know,
can't
by
tell
the
me
way-
she doesn't have the
Oh, she can,
capability.
and they are across the street. They are across the street. I just want to, and I'm not disagreeing or disputing what you're saying. I'm just saying that the logistics, I just want to be clear on it. The clerk also had another very interesting way that we may be able to handle that, is if they read the title, and we've done this very recently, if they read the title as corrected, and the changes could be made between first and second reading to comport it. Is that correct?
So what I'll tell you is that normally when you have an ordinance and you go ahead and you publish the agenda to the public and it's a first reading and you change that ordinance, so long as the changes you make are not significant enough to change the title block, you don't have a problem moving forward. When you change the title block is normally when you have to come back and kind of start anew, where you have your first reading again and then your second reading.
Councilman Carlson.
No, never mind, sorry.
Councilman Vieira.
Thank you very much, sir. Just really quickly, I mean, I say we go with advice of counsel. We either change something that changes the title, which unless I misunderstood Councilwoman Hurtak, she wished to go as we have it now, or we change it and we wait another week. I mean, we have land use hearings in 2.5 hours, so I suggest that we go, and I defer to the advice on council on the choices that we have.
If this,
Councilwoman Hurtak.
if this is part of the title block, then that is the problem is several of these ordinances have stuff in the title block that shouldn't be there. I mean, that's quite honestly, as I'm looking through these and as we're going to be discussing them, there are quite a few other things that shouldn't be in the title block. So we're going to have to make some changes anyway. So the issue is,
Mr. Shelby.
If I could finish that sentence and not to interrupt, but the issue is, can these changes be made and done in a form or fashion that comports with the Florida law that requires how this is going to be passed and adopted, if that's council's pleasure, on second reading, and make publication? So why don't we proceed, and then we can see how things can work logistically. You mentioned next week's meeting. The next week is a CRA meeting, unless you have something that you want to do as a special call or add to the night meeting agenda. There are many ways to be able to address this. But let's see what council's pleasure is, and we'll see if we can, we'll see what we can do to make it happen.
Councilman Carlson.
Yeah. Considering how these dates have been pushed and pushed and pushed and pushed, I would prefer not to push it again. I don't want to put language that might be misleading or confusing in there. But considering that the charter was changed substantially with 2 paragraphs in a 2018 memo by a city attorney, I would request, have you made a motion on this, right? Maybe I would ask for you to amend your motion to add that you would request, if you include the title block the way it is, that you would add to it a request that the current city attorney write us a memo for the file that would say that her interpretation is that this attorney works for the CRB, not for the police department, because some future city attorney may misread that the way others have.
If I may, the name of the board is the Citizen Review Board for the Tampa Police Department. For the Tampa Police Department modifies Citizen Review Board. It doesn't modify who the attorney works for. The attorney works for the Citizen Review Board for the Tampa Police Department. That's the name of the board.
So I think it would
We're
just
getting wrapped around the axle on something that's already in there.
I just
That
think
is the name of the board.
I just think it would be helpful to put that in writing so that we could somebody in the future could refer to it. You know, we have so many, what I would call misinterpretations, like the line that says something like, the city attorney is the final word on legal opinions. And that's been misconstrued to pretend, to imply that the city attorney is the Supreme Court of the city and makes judgments and rulings, and they're just legal advisors. There's emphasis there on final opinion versus legal advice. And so I just want to make sure that nobody in the future misconstrues this, because a lot of power has been taken away from city council. It's not about taking power away from the administration, it's about taking away power from restoring powers of city council and making sure that nobody takes powers away in the future. Thank you.
Councilman Goods.
Mr. Shelby, this is where you come in, so this is where you're the coach. Like I said before, this is where you come in. I don't care about the city attorney right now. I care about you telling this board and giving us a directive to move on. That's what we rely on you for, not to be nice or play nice with them. They're going to do what they do. I need you to be the coach to do your job, to tell us what you believe Ms. Hurtak are the right directive to move, for this lady to know what she needs to do, for this council to know what we need to do. That's what I'm looking for. I'm looking for your leadership to say, council, in my opinion, this is the route we should go to get what you want accomplished, to get it on the ballot, whatever needs to be removed to get the job done. I need you to be the coach.
Yes, sir. With regard to what Ms. Zellman said, with the name of the title being in there as for the Tampa Police Department, that is something that I actually brought up because of the fact that is the title within the within the city code. There is, as was stated by the city attorney, the other jurisdictions that were cited, Miami, Key West, those are perhaps a different form of government than we have in the city of Tampa that is operating under a different charter. Our charter has nothing anywhere in it now that uses the word Civilian Review Board, CRB. And that comes from how this board was created. And rather than, and if we had maybe more of the luxury of time to be able to do this, if it were council's pleasure, and the process went through and it was vetted properly, maybe something like what you want to have, that have been cited by members of the public relating to a civilian review board, maybe the next charter review commission or however council wants to do it.
But what about now? Sorry.
Now I have different variables that I am concerned with. You can, if you want to change it, if you feel strongly that you don't want that in there, if you don't want, what you don't want to have is you don't want to have any misperceptions or miscommunications by the public. You don't want anything misleading on your charter ballot or the ballot summary. That is the most important thing. You're also limited, and just by way of background, the number of words these things can have in it. So that all being said, my main concern is there is one publication in this city that does legal advertising that this city retains. It publishes one day a week. We're in a holiday season, and that's why I'm concerned that this has to be such that if you're going through these efforts and you want to make it on the ballot, we have to make sure that we follow that time. And my suggestion is, my recommendation is, state what it is you think is necessary, and then we have to figure out how we're going to handle the time frame to be able to get it back to you. So my suggestion would be, if that language, if you feel it's misleading, and if Mrs. Elman would agree with that, I say then, even though I believe it is in this section, because there's no other section where it could fit into, it fits into that department. So my suggestion is, as a council, with your leadership, you tell us where you want it to go, and if it means us having to work with Bryant, Miller, and Olive to get it to you in a timely fashion, if it means changing the council schedule to be able to get it into a timely fashion, we will do what it takes in order to be able to comply with Florida law to get this on the ballot in a timely fashion.
Okay, then I will stick with my motion as stands.
We have a motion made by Councilwoman Hurtak, seconded by Councilman Maniscalco. Any further discussion? Roll call vote, please.
Maniscalco?
Yes.
Miranda? Hurtak?
Yes.
Carlson?
Yes.
Goods?
Yes.
Viera?
Yes.
And Citro.
No.
Motion carried with Citro voting no.
Agenda item number 20. Councilman Carlson.
Does that mean that we need to schedule another first reading, or are we okay? If we're gonna schedule something, we have to do it now, today.
This was to change the language.
Okay,
We're not at first reading yet.
okay.
But we could,
Yes, please. I'm sorry.
Councilwoman Hurtak.
but we could have a first reading possibly on the 8th.
We could. I have not talked with council about it. We may even be able to have a first reading this evening if such a thing were possible. I don't know.
Okay.
Or we could have it next week, but
Okay.
we have not gotten to that point.
Okay.
And we don't know what's ahead of us in terms of what.
That's why I think we're putting the cart before the horse here.
Ms. Cowan.
Okay. The next ordinance before you is amending section 2.02 qualifications, and it's addressing the term limits of the city council members. City council's motion was very clear on this, to delete the end of the section, thereby limiting all members of the city council to serve 2 consecutive full terms, eliminating the ability to immediately run and serve as a council member for a different district. I believe it was referred to as district hopping, and this proposed language removes that.
Any questions?
Yes, sir.
Councilman Maniscalco.
So I was thinking about this, and I think it was maybe 10 years ago or so, the council made a motion if people resigned from council to run for other seats, and if they lost, they couldn't come and jump. You know, if it was a November election they were running for, they couldn't lose and then come back for the March election. They would have to sit out 4 years. And I think this goes with that, you know, along the lines of that you know, we have term limits. We have 2 full consecutive terms, and then you know, a council member is allowed to go to another seat if it's open, but this would limit it beginning in 2027, so I don't see any harm or foul in this. Thank you.
Any other comments or questions? Councilman Miranda.
Thank you, Mr. Chairman. I believe that Mr. Muscapa is correct in a way. I think that was intended, let's say that you have an opportunity to jump ship or go somewhere else, wherever your mind may take you, your body wants to go run for another office outside the city of Tampa. You want to run for a judge, you run for state attorney, you want to run for a county commission, you want to run for whatever. That if you leave before your term is ending in the city, that's what it means, that you have to wait out 4 years before you can run. Yeah. That's what that means, yeah. This section here. This is a little different, and I'm not talking about myself. I'm saying that if you do this, you'll have very few individuals that understand what happened 10 years hence, past the time where you're talking of something, and you leave like a library's empty. You're going to look for something, you're not going to find it. So in fact, there's a thing that I really believe in and admire, that every 4 years, you may want to run, but you may not get elected. That the public has that right to do that, and the public does it on a well-mannered situation. So I'm not going to vote for this. It's just the public has a right to vote you up or vote you down, and I'm not going to take that right away from the public.
Councilman Carlson.
Yeah, I know that there was some discussion a couple months ago about ideas that have been suggested during the Charter Review Commission and were rejected. And I did not propose this one, but just for disclosure, during the Charter Review Commission, I recommended no more than 4 consecutive terms. So that would allow someone to be in a district and then roll to a citywide. I'm fine with this one, but I would like either the 4 terms or 2 terms, because I like to see turnover of people.
Councilwoman Hurtak.
I'm open to that amendment as well. That's fine with me, because I think that balances knowledge and time. So
Okay.
I'm absolutely fine with that.
Councilman Maniscalco.
Councilman Miranda brings up a good point. Elections have consequences, and there are elections every 4 years. If people don't like the individual, there's another candidate, you know, the other candidate wins. So, I don't know.
Mr. Shelby.
Just a reminder, council, and for whatever weight this has, I make no comment, but just a reminder that Tampa is unique in one great sense. It does not have staggered terms. I'm not familiar, frankly, with another jurisdiction in this state that does not have staggered terms. Everybody is on the ballot every 4 years. What the practical effect might have in terms of institutional memory or things down the road, I can't say, and I'm not going to speculate, but just so you know that it's unlike any other jurisdiction that I'm familiar with.
Councilman Miranda.
And just sort of this, when I heard the word, all of this does not come from a Charter Review Commission. We, some years back, in fact, put the individuals in the Charter Review Commission. I know how there was over 10 of them. I forgot how it was. I know the mayor had so many, the council had so many, then whatever. And they brought the recommendations to us. In this case, it's us bringing the recommendations to ourselves. Am I correct? Mm-hmm. So that's flawed in itself. That's not transparency. That's not coming from somebody other than us. Not coming from a group of people that we appointed to do a responsible, and they did a fantastic job. In fact, 4 of them are here. 3 here and 1 there, if I can count to 4. And those are the things that I see. So that commission is not involved in this. We set that commission in order to have transparency and clarity to that somebody else other than us doing this. So we're doing this ourselves. That's in reverse of what the whole thing was set up about to be way back 4 or 5 years ago. That's if I remember correctly. That's all I'm going to say.
Councilman Goods.
You know, I respect what Mr. Randa is just stated, but when that commission was put in order, no city council members were on that commission. So they don't understand what we went through and the information that we was given and were not given. Now sitting as a city council member, I can see some of the flaws in that process. And there are a few. And now sitting as the actual board member, seeing some of the things that we didn't get a chance to really review all of the charter, but seeing some of the interpretations of how we operate in this board works, we missed some things. And I'm glad that I had the opportunity to be here this term to see, to be able to argue some points. But again, the charter is not perfect. It does have some vagueness to it and interpretations to one. So I think being clear on some of the issues makes it better. So people have a clear understanding of what it means versus a broad spectrum. I can look at a police SOP. Some things are clear cut. Some things is led to interpretation. Or how the writer who's giving discipline or whatever writes. Anybody can be disciplined, depends on who the writer is and how they perceive the perception of it. There's no difference than some of the stuff that's in this chart. So, again, I sat on that board, several members here, Ms. Zelma sat on that board, and I still contend that some of the stuff in our charter we missed, and had we known what we know now, things might have would have been different. And maybe we had some of the concerns from the previous council to tell us what they thought. We might have could have addressed some of those issues. I don't know. But I think we missed a few things. But it's glad that we are looking at what we're looking at now, just to move forward.
Councilwoman Hurtak, and then we're going to go to Councilman Vieira.
So if we wanted to follow what Councilmember Carlson said, we could simply take away the lines that are gone through in this language up at the top, if what you're looking at, and just add to not exceed a total of 16 years or 4 full terms.
I can go with that.
So the language we struck through, the except for that person who is represented, we could keep all of that and then just add to not exceed a total of 16 years or 4 full terms. Would that work? Could we do that instead?
You can certainly make that change.
Okay.
It will change everything. You'll have to go back, to first reading on
Yes,
this, as we've talked about before.
But then down at the bottom, the only issue I have is the actual language would be changed to eliminating the ability of members of city council who have served 4 consecutive full terms to immediately run.
No, I think there would be some other language that would be
Okay.
changed in that.
Okay.
Yeah, because
But-
we want to be really clear to the voters of what it was versus what it's becoming.
Okay.
So there would be some additional language proposed for that.
Councilmember Carlson, does that work for you? Do you like that amendment? If not, I can take it out. I'm just fine with 4 terms
Mr.
for the
Chairman,
institutional memory, like Councilman Miranda said.
the
Councilman Carlson.
Yeah, the only thing is there are situations like Lewis faced where he filled 2 years of an existing term. And so if he got elected the fifth time,
okay, I'm
then
sorry.
he would hit 16 years and he would be capped out in the middle of a term.
You're correct. I'm sorry. So then to not exceed a total of 4 full terms. How's that?
Yeah, four consecutive terms.
4 full consecutive terms. Okay.
Councilman Vieira.
Yes, and the reason I voted for this the first time is it makes this consistent with what applies to the mayor, and I think that's good. I think to cap it at 16 years would be misguided. It wouldn't be a poison pill for me, but I respectfully think that would be misguided. There is something for institutional knowledge, and I think when you allow someone to have a 4-year break like we do as mayor, you open the field, which is I think the whole idea of term limits. There's always arguments for and against term limits and whatnot. A lot of people argue for it in Congress, but for 34 years, from 63 to 97, we were represented in Tampa by Sam Gibbons, one of the greatest members of Congress around who did such great work for Tampa. So there's always good things on both sides. I think to cap it at 16 years or whatever that may be would be misguided. Again, not a poison pill for me, but I do think that that's misguided. What I was looking at in supporting this the first time was to have this consistent with what we do for the executive.
Councilman Maniscalco, and then Councilman Miranda. Councilman Maniscalco, then Councilman Miranda.
I was thinking back over the last 60, 70 years, and how many council members served more than the 2 or 3 terms, and I can only think of 4. Salcena, Miranda, Copeland, and Duncan. And Copeland and Duncan haven't been in office since, I don't know, the 70s. Whatever, you know what I'm saying? But it's, the chances are slim that these, you know what I'm saying? Again, elections have consequences, and we've had many council members over that time period, and a very small group have, you know, has continued. So is it even necessary? I don't know.
Okay.
Councilman Miranda.
Thank you very much, Mr. Chairman. When you look at elections, look at the Congress and the President. The President only served 2 terms, period. As I understand it, you can serve 4 or lose, I guess you can come back. But the House, the Senate, and there's where that knowledge stays. Whether you like them or not, whether you like Pelosi or not, whether you like the gentleman from Kentucky or not, they're there. And will you like the new speaker coming up now? That's another question. Will you like whoever's going to be president of the Senate? That's there. And those don't change because the government can change, but that's the leader. The rest of them, they have to negotiate. Same thing we do here, in a way. So we want to change it, and that's why I'm not going to support this. It never went before the Charter Review Committee that I know now. When we're making changes, not quite 4 years out, when the Charter Review Commission made the recommendation to us, and it's supposed to be open once every 10 years, if I recall. And I haven't read it, but that's what I recall. So now we're doing it in 3.5 years, and that's what, there's no Charter Commission. We've taken over that. Not directly, but indirectly.
Councilman Carlson.
Yeah, just to comment on that, the Charter Review Commission created the Charter Review Commission to come back, so that the process before that was that City Council would modify. And the last City Council, which several of you served on, created the Charter Review Commission. So we're actually following the original rules, not the ones that were created by the Charter Review Commission. And we happen to have unique expertise. And I won't revisit all the things that I had proposed, but the intent of what I was saying a minute ago about the 4 consecutive terms is if you change this and just take out 2 and put 4, then all it would say is that after 4 consecutive terms, you have to sit out for 4 years. Mm-hmm. So it doesn't. I think if the proposal I had several years ago, the Charter Review Commission, was 4 terms total ever. But but if we were going to modify this, what I would put is that it would be 4 consecutive full year terms, and all the rest of this would be the same. So after 4 consecutive terms, they would have to sit out for 4 years before they could run again. Mm-hmm. But if you all want 2 instead, I don't care. I don't plan on running more than 2 anyway.
Yeah, I'm fine with keeping it.
Councilwoman Hurtak.
Sorry, I'm fine with keeping it as is, or doing 4. So it's really the pleasure of my colleagues. I agree with Councilman Carlson. I'm fine with either.
Any other comments or questions? I just have to make this statement, and I mean to offend no one, especially our outside independent attorney that is here with us. There's 4 members on this council that served on the Charter Review, especially with our city attorney that served on the Charter Review. 13 months. 13 months we spent deliberating on the changes that the Charter Review Commission put together. As we've already seen here, we're making changes now as we're going. I'm feeling that this also might be rushed. And again, I mean no offense to anybody, especially our outside independent council that we have now. We have the mayor, we have city council that's all elected at the same time. I've heard many times, wouldn't it be great to have a new mayor and all new city council? We can start afresh. You're going to have 8 people who have no knowledge of institutional within the city. And that mayor may come in and wipe out the whole staff, which would mean you're going to have at least 2 years of gaining that information. I can't support this as written. I could support the 4 terms, but not this. What is the pleasure of council?
My motion will be to strike the strikes and add to not exceed a total of 4 full consecutive terms. And then the language at the bottom would just change served 4 consecutive full terms to 2 consecutive full terms to 4 consecutive full terms. Here.
We have a motion made by Councilwoman Hurtak, seconded by Councilman Carlson. Roll call vote.
Carlson?
Yes.
Goose?
Yes.
Vieira?
Yes.
Hurtak?
Yes.
Maniscalco?
No.
Miranda?
No.
And Citro.
No.
Motion carried with Maniscalco, Miranda, and Citro voting no.
Agenda item number 21.
Okay. The next item before you is an ordinance addressing section 9.01, and this is the creation of standing boards.
Yeah, at 4. And that's what I did. And then you still voted no. Wow, I did that solely for you.
And basically, the only change in this ordinance was clarifying that the standing board will be created by city council by ordinance without the mayor's recommendation.
Councilman Maniscalco.
Thank you very much. And I think this goes back to the summer of 2015 when the issue of creating the Citizens Review Board that we've discussed earlier today, and there was discussion back and forth between the city attorney, the city council attorney, the city council, and the mayor regarding who has the authority to create boards. And the opinions that we got from what I remember, now 7.5 years ago, was that one of the opinions was that the city council had the authority to create the board. The mayor at the time disagreed with that per the response from the city attorney that only the mayor had the authority to create the board. It became a heated discussion. I think we came to a stalemate, and the board was created, but it came down to the mayor and the city council as to how many appointees to that board they would have in order to keep it balanced. We came to an agreement. We've amended that since, and now we're talking about the CRB in regards to independent attorney now. So this is a 7.5-year discussion, but from what I remember, there were differing opinions. One attorney said that we had the authority. The city attorney said that no, and that only the mayor could create the board. So I'll wait to hear what other council members have to say about this, but that's what I remember and my understanding, so.
Anyone else? Councilman Goode.
All right, well, in my understanding of this now, this council doesn't need the mayor's approval to create a board. We can do it by ordinance. Am I right, Mr. Shelby?
The full answer is, under the home rule authority, you, in your legislative ability, have the right to create an ordinance. The question is, what is the mayor's remedy if she does not like that ordinance? The answer is in the charter, and that is the veto. And there's a process for a veto, and there's a process for, in the exercise of its legislative authority, if it disagrees with the mayor's veto, city council can override it. There's been a question of interpretation as to what this charter, what this provision in the charter does. Does it then limit the ability of the city council to create a board without the prior approval, the pre-approval in a sense, of the mayor? But even after that case, the mayor still has the right to veto it. Or does it mean that, for instance, this is under a section of, was it 9.01? Is that the section?
Yes. Yes.
That's under the section of boards. It does not say city council boards. It does not say mayoral boards. But the question is, does that apply equally to the mayor and to the city council? And there was question as to whether it did, and there was a question, and this was raised in, I believe, 2018, was it? What the interpretation of that sentence was, and how was it applied, and that was the subject of an interpretation question. And this was a proposed fix to be able to make it clear as to what the authority is related to standing boards and ad hoc boards.
All right, so, again, going back to my question.
Yes.
What I'm reading right now, in this provision right now, if passed today, this council has the authority to put a standing board in place as ordinance, correct? I need my yes or no answer. If it's not clear, then that's the point. Let's make it clear if we're gonna pass it. I don't wanna pass something and still we're not clear on the interpretation.
Well, who has the final say as to the interpretation in this city is the question. Is it the voters, or is it the question? The question ultimately is.
I wanna make sure, if I'm gonna put something to the voters,
Yes.
the voters know what they're checking, yes or no, to saying this council has the authority to make any board they want in the city by ordinance. That's what I'm asking. So I wouldn't care if the mayor disagreed with my board or not. If this council said they wanted to enact some type of board, and we passed it, he or she could veto all day long. But if this board comes back with a 5-vote count, that board passes, correct?
That would be my interpretation, but the question is, that might be a question you want to pose to the city attorney, if that feels like, if you don't.
I don't need to pose it to the city attorney right now. I need to know if this board right now has this young lady right here to write our charter orders to put on the ballot, is it standing? So if you can't answer it, ma'am, I'm gonna ask you that question. If this board is asking you to write in the charter for the voters that this council has the right to enact any board we want as into ordinance, and the voters voted that, would that be the standing interpretation?
As the language has changed, it would be that, yes, that the board could be created by ordinance.
Councilman Maniscalco.
The board would be created by ordinance, and then however your ordinance proceeds. I'm not familiar with your veto powers and all of that.
Councilman Maniscalco.
I think I can clarify, I hope I can clarify. So, my opinion, this is no attorney's opinion, for what I've understood from being here in 2015 when this discussion came up, the city council has the authority to create the board. The mayor has the authority to veto that. With a 5-vote supermajority, the city council can override the veto. What happened in that situation was the last administration never used the veto power. In the situation with this board, an agreement was made. The mayor proposed who appoints what, and we settled it. Why? Because I spoke to the mayor. I know sometimes I waste my time in mediating, but I wanted to bring it to a close. I spoke to the mayor. I remember he called me. What about if, you appoint this many and this? What about that? You think? I said, I'm sure council could go with that, and we settled it. It never got to that veto, overriding the veto. Anyways, so we don't know what would have happened because it never got there. We reached a settlement. But the point I'm trying to make is I don't think this is necessary because from speaking with a variety of attorneys at the time, Mr. Shelby, the city attorney that was there at the time, city council has the authority to create the board, so we don't need to do this. We never got to that veto.
I'm trying to figure how you're saying it's not necessary because you never exercised your power because you felt what I've listened on that order, because I was here that whole time when it all went on, that this board and the interpretation of Ms. Mandel was the mayor had all the power to do whatever. That's what I interpret from Ms. Mandel at that podium. So you might have made a back deal with the previous mayor, but Ms. Mandel at that podium said the mayor had the authority and this council did not. Am I right, Mr. Shelby?
That's my recollection.
Correct. So for the say we don't need it, I respect Mr. Maniscalco. I disagree. That's why I asked this young lady, what is the interpretation from the actual her verbiage? That way there's never ever any doubt about if this board has the authority or not.
Councilman Carlson.
Yeah, that's the way I remember it too. Ms. Mandel said that and I was an activist then, but that only the mayor had the right to in whatever way create or approve the creation of committees. And then they hired an outside attorney, Gwen Young, who's a great person, but attorneys, this is why I had the whole discussion in the charter about attorneys. If you hire an attorney, the attorney works for you. And technically the city attorney works for city council and the mayor. It's described in that detail in the charter. But in reality, especially at that time, the attorneys didn't. And I don't think they did anything wrong. I think they were told to do certain things. So Marty's opinion at the time was that it was our power and we could do it, and their opinion wasn't. They hired an outside attorney as if that, again, was the Supreme Court, and it's not. That's the kind of situation why we need a conflict resolution process, because we may be headed to another one of those again. Hopefully, Ms. Zellman has a different view than some of her predecessors who have misinterpreted the charter. But in this case, I think we absolutely need this because there's so many misinterpretations of the charter, whether the city attorneys in the past were bullied or whatever, they misinterpreted the charter, and it's put the city at risk and of lawsuits and liability, and we need to make sure that we cap some of these holes and make it specific. And so this doesn't do any harm. It doesn't take away anything from the strong mayor form of government. It just codifies what is the reality from the point of view of the city council. Thank you.
Councilman Miranda.
Thank you. You know, as I look back and I said, and I was trying to find in my mind how many times a city council has overridden the mayor in a 5-2 vote. I can remember once. I'm trying to think it out how many other times, maybe some other place that I remember. What I'm trying to say is that we're looking here to change the power of what we have in the mayor's office. I'm not saying that we're right or wrong. I understand both sides. But if you want a strong mayor of government where one person is responsible for the administrative stuff and 7 are individuals for the legislative stuff, then you have to make you work together. And in the future, it may be something that the council and the mayors can't work out together, cannot work out together, and the council may want to create all kind of boards without the mayor's permission or a blessing or whatever you want to call it. But that mayor still has veto power. And it's only been used, that I remember, and you can check history, one time, and it was in 1974. And it was a raise between the fire department and the administration. And it was settled on the council overriding the mayor. That was the only time I can remember. I'm not saying there's not another time, but that's the only one that I remember. It was Local 755, and Sampson Arnie was the president. Arthur Larandy was the vice president. And I can tell you what happened. It was in the office where the clerk sat. It used to be the mayor's office. Nobody remembers that. In fact, I hate to tell you this, there was no phones back here. There was no offices for council members. There was a slot like a pigeon comes in, this is where you got your mail. And there was one phone. That was different times. I'm not saying we should go about that. Let me clarify all that. But only one time that I can remember was the council ever overriding the mayor. And maybe there was another time on the budget, but I think it was settled. I'm not sure. Thank you very much. But I'm not going to support anything that leaves the mayor out, because it starts to wither away and starts with 2 different bodies not communicating with each other, and I don't want the public to go through that.
Mr. Shelby.
I'm concerned that there is the opportunity for misinterpretation here. I think what this does is it goes to what Councilman Goose had to say with ensuring, and you were able to do that with direct questioning of an independent or an outside counsel as to what the interpretation would be. This came to fore when the city attorney prepared this last time around for changes to the CRB and prepared a memo for council, which was responded to by an attorney for the ACLU. And in that discussion, there was a decision about how this particular provision was changed. My concern as city council attorney, with regard to the creation of the board, to go back to 2015 to clarify what Councilman Carlson was talking about, was that the issue came up when the previous mayor was quoted in the newspaper as saying, the city council does not have the power to create this board, and my city attorney agrees with me, or words to that effect. And that questioned in my mind, as your attorney, your home rule authority to be able to create an ordinance and to be able to create a board by ordinance, because the mayor's remedy, as Councilman Miranda correctly states, is in the veto.
Correct.
In this situation, there was a period of time when there was a great deal of discussion between council and the city attorney, in which I was involved. Does the mayor have the ability to remove that home rule power under this charter by preempting council, by creating an executive order doing something before council has the opportunity to act, which was the process in 2015. Before council had an opportunity to act, an executive order was created, and therefore the argument was made that council lost its legislative home rule authority. The section that I relied upon in 2015 was changed by the Charter Review Commission. This section in section 9.01 was boards, and the question ultimately became, but for the lack of a comma or for the lack of a period and a capital starting the next sentence, it was subject to two different interpretations. And that's why, for no other reason, because of the fact that it was subject to interpretation, in my opinion, that interpretation, or one of them, could have been used to infringe upon what I viewed as council's rightful home rule authority by an interpretation of the charter. It's a clarification. You heard what the clarification is, a plain reading by an independent attorney that council, it doesn't take anything away from the mayor, but it restores to city council what, under home rule authority, every legislative body within this state has the ability to do.
Councilwoman Hurtak.
Thank you for succinctly saying exactly what I was going to say. That's the whole point of this. This takes no power away from the mayor.
None.
Because the mayor still has the ability to veto it.
Absolutely.
And as Councilman Miranda has shared with us, very few overriding vetoes or overriding votes have occurred. So this really is about clarification. That's why I made this motion, and I am presenting it as it stands right now for approval.
Councilman Vieira.
No, I just say that we move forward. I second it. Let's take a vote. I agree.
Motion made. Any further discussion? Motion made by Councilwoman Hurtak, seconded by Councilman Vieira. Roll call vote.
Carlson,
Yes.
Goods,
Yes.
Vieira,
Yes.
Maniscalco, Miranda,
No.
Hurtak,
Yes.
and Citro.
No.
Motion carried with Miranda and Citro voting no. So you're adopting the ordinance as is. So did you read the title of the ordinance? You need to read the title of the ordinance if you're going to adopt the ordinance.
Oh, okay. I apologize. Let me read the title of the ordinance. Apologies. An ordinance relating to the government of the city of Tampa, Florida, submitting to the electors of the city a proposed amendment to the revised charter of the city of Tampa of 1975 as amended to amend section 9.01 to clarify that standing boards shall be created by city council by ordinance without requiring the mayor's recommendation, providing an effective date.
Thank you. Motion carried with Miranda and Citro voting no. Second reading and adoption will be held on January 5th, 2023 at 9:30 a.m.
Councilman Maniscalco.
And just one final comment. I don't think this merits a veto. Again, it doesn't take away power from the mayor. It just offers clarification. I've sat through this discussion from 2015 on, and I appreciate Mr. Shelby's comments from 2015, because I agree with what he said at the time. We avoided a fight. We worked it out to a certain degree, but this does not merit a veto and having to go there. It doesn't hurt anybody. But that's just my opinion. Thank you.
Thank you. Agenda item number 22.
Yes, before you now is an ordinance revising section 6.03 appointments, and this is addressing the appointments of city department heads. This is clarifying that the mayor will nominate the department heads and council will appoint or disapprove the nomination. If disapproved, then the mayor will submit another nominee. The mayor may appoint an existing city employee to serve as an interim appointment for a period of not more than 180 days.
Councilman Maniscalco.
So this is another one that I had thought about these last few days and looked at and read the language here. So from my understanding, the mayor can only appoint to a vacancy for a city position an existing city employee. Is that correct? The mayor has to choose from the existing active city employees.
No.
The mayor may make an interim appointment of an existing employee who can serve for a period of, yes, not more than 180 days.
But they can only choose an existing city employee, or they can pick anybody from whoever they choose to?
This language would have them may make an appointment of an existing city employee.
So my question is this. We have Chief of Staff John Bennett in the room. John Bennett was employed by the city, retired, and went to another jurisdiction to work. Therefore, the mayor, having come into office, would not have been given the opportunity to appoint John Bennett as interim chief of staff because he wasn't an active city employee, because he had retired. And then that's the thing. My problem with this is, you know, one of us becomes mayor and we have a right-hand person that is whatever, our person that we go, there's nobody better for chief of staff position. I'm just using that as an example. That mayor cannot appoint that person because they're not an existing city employee, even though they're the greatest, whatever, but it would prohibit the mayor from doing that. So a mayor would come in with the new administration and not really be able to appoint whoever they would want to because they have to choose existing city employees. I just want clarity on that.
Councilwoman Hurtak.
That's a great question, but actually this only applies to interim. You can nominate anyone you want from like the whole world, but they're saying that in the interim, it should be a city employee so that you can't choose somebody, you know, you're the world's best chief of staff from France and you're going to bring them over and then you're going to make them an interim until they're voted on, which basically is subverting the power, the going through council.
Okay.
So in the interim, yes, you have to choose someone from staff, but you can still hire that your best French chief of staff, but it has to go through approval of council before that person can start working.
Okay.
That was I know this was Mr. Good's ordinance, but did I get that right?
If you don't mind, I would like to go to Ms. Cowan, and would you concur what Councilwoman Hurtak just stated?
Yes, that the mayor can nominate anyone. There's no restriction on who they can nominate for the heads of department or administrative personnel, but those that the city council will then have to make that appointment. The restriction becomes with regard to the interim appointment as that being only an existing employee and only for 180 or no more than 180 days.
Councilman Maniscalco, does that answer your question or your thoughts?
I guess so. So the mayor really would not be prohibited from appointing whomever they wanted to.
The mayor doesn't appoint. They only appoint an interim. They would nominate a person that would be considered by then the city council for appointment. And
So-
city council would either approve that appointment or disapprove it. If they approved it, they're appointed. If they disapproved it, then the mayor would need to submit another nominee.
So would the mayor be able to directly nominate somebody and say, I don't need an interim, this is the person that I want, and it be voted, approved by council or not? Correct? Okay, so, we have interim there, whatever, but if they have, whoever they're choosing that is not a city employee, they can say, this is who I want, not an interim, this is my nominee, and come to us. Now, if that nominee is shot down or voted down, the mayor cannot resubmit that individual, correct?
As it's written now, in what's before you, that's correct.
So
They
it
would
would-
need to submit another nominee, a different nominee.
And I can understand the argument of, well, the council can vote that person down, and now they won't have the opportunity to get to know that person better, for a resubmission of that nomination. I mean, I don't think that has anything to do with us. The due diligence should be, whoever that nominee is, that they should, go around and meet the council members ahead of time and all that, so. Okay, thank you. My questions are answered.
Mr. Shelby, you were going to say something? If not,
Well,
I'm going to Councilman Goods.
I'd rather hear from the council.
Councilman Goods.
The intent of this change is simple. You look at our federal and our state. they're a nominee. They're not appointed. They're a nominee at first. And the nominee, the president nominates someone to go before the Senate. And then the Senate hears from that nominee to make sure that nominee fits the mold of the Senate. And then there's a confirmation for appointment. So the mayor can nominate anybody they so well choose. We appoint. That's the only power we have at that time. We do the appointment. Now, if someone leaves or resigns, the mayor has the authority to still nominate somebody. But if you're talking about waiting to nominate to get an appointment for us, there should be an acting person within that department that can run that department until that person comes before us for confirmation for the appointment, which makes sense. You know, you can't having someone outside come and that person has not been appointed by this body to run city business. That makes no sense at all. But the interim person, the number 2 person, number 3 person, whoever, can run it until that 90 days up. And I'm going a little stretch with the 180 days. So I'm giving you that one.
May I offer?
Ms. Travis, please.
Thank you. So there's just Nicole Travis, Administrator of Development and Economic Opportunity. So there's just a little difference. When you talk about the president makes nominations, it's in the Constitution for that procedure to happen that way. And so there's a big difference in our governing documents on how this works. But I want to talk to you, I'm not here to talk to you about interim and the appointments. I'm coming to talk to you from a recruitment perspective and a practical implementation perspective. You council members have talked about recruiting the best and the brightest. There is no C-suite executive that will take a position that has to wait on confirmation from a political body before. No one will do it. I would not have come if it weighed in the wings of that. Now I understand why this has come to a head, and I understand which appointment you're talking about and which head of this, but you cannot recruit the best and brightest in political positions. I would not have gotten my deputy. We've been working closely with you guys for the last several months. I would have never taken this job if my fate, leaving a good employer that I have a great relation and cordial working relationship with, to come to work for. So from a practical standpoint, I'm just talking to you about the implementation of what may happen here. You cannot recruit in local government where an appointment is dependent on a political body. You can't.
I don't believe anybody will leave their job.
Councilman Vieira.
Well, she was speaking to me first, so I want to respond to her.
Well, I was responding to the council.
Councilman Goods.
So I can adhere to some of your point. I don't agree with all of it.
Sure.
Because if I'm at a job already and I'm applying for another job, I'm not going to leave my current job until I know I got the other job. I don't think anybody's going to do that. Be it political or not, and I love you to death, but being political or not, I'm not leaving my job until I know I got that job.
That's not how it works in the practical environment. I'm telling you as a C-suite executive, that is not how it works in the practical implementation. If I know that I have the job, if I know that the job is waiting in the wings and it's dependent on a political body, I have to give notice to my employer. So you're talking about someone leaving their job, putting themselves out publicly. You already told your employer that you're leaving and you don't have confirmation that you have a job. No, you cannot recruit top-level executives in that kind of, you just can't. Even when you look at city manager searches across the state, when they hire recruiting firms, there's a certain level of anonymity to a certain point, and then it's public knowledge. You could look at those city managers that applied for the position, that didn't get the position, and see how long they're still there. You're putting on notice to your employer, I'm leaving you, and then you have no certainty of moving forward. So I'm just telling you I'm not weighing in on, you guys know me very clearly, I'm not gonna weigh in on the politics of it. But from a practical standpoint, when you say you want to recruit the best and the brightest, David Ingram that was here with you this morning would not have come knowing that that they have to come, he has to come before a political body. And you had a recent experience of someone seeing what happens with political bodies. You had a recent experience with that. So I'm telling you, just from a practicality standpoint, the rest of the stuff, I'm not getting into the politics of it. But this one, when I know that I have a lot in my portfolio that I recruit for the best and brightest that have to be appointed, and I tried to give it to you immediately. I put out the memo to you and tell you this is who it is, this is who is coming, and I know that you guys have a lot of trust in me and the work that I'm doing and the relationships that I've built. But I'm here to tell you that this will backfire on you for your recruitment.
I just believe that's taking some of council's home rule away. That's just my personal opinion.
I'm sorry?
I just believe that's taking some of council's home rule away. It's council, after we appoint someone, we have no authority over that person. If we don't like that person, we don't like their work ethic, we don't like what they're doing, we can't fire them, we can do nothing. So to me, taking our home rule away from us, saying that we want to make sure if the public is in outrage about some things, you're saying for us not to be able to have a home rule. I can't support that.
But there's an accountability. There is an accountability. The mayor is the executive and administrative arm of this. And so in the way that our government is set up, you have the administrator, the administrative arm of it, that's the CEO. The buck ultimately stops with her. And so when someone is calling, if someone's upset with the convention center, if someone's upset with Mr. Drumgo or Elise or Abby, they call me, they call us. Ultimately, yes, you cannot do the hiring, firing. You have one employee, you have your city attorney, but that's the structure of the government. And to do this, and you can call for accountability, I understand, and it's a stretch.
I respect your opinion.
I know, and I respect that we can respectfully disagree on it. If I can't recruit the best and brightest to do the work here, then I don't have the tools to be successful here. And you have to really, I'm just telling you from the things that you want to do, that this is a challenge.
Councilman Vieira.
Thank you very much, sir. Yeah, I mean, I'm voting on all these the way I originally voted, unless if something happens to change my mind. I voted against this for a number of reasons, including this. I believe that ultimately this will result in too much of a burden placed on the search process. There's already mechanisms in place. I wish, and I understand Councilman Good's concerns who made this. They're very legitimate, very reasonable, very well made, et cetera. I just think that as presented, within the time that we have, it's far too expansive. You have an executive that is trying to recruit folks, et cetera, and this would place burdens upon that process that would ultimately play horribly within the private sector or someone making a lateral public sector move. It's just something, again, I see the challenge that's being addressed here, but I voted no the first time, and I'll vote respectfully no this time. Thank you very much.
Councilwoman Hurtak?
I think I feel that people are confused. We already have this power. Like, we're not talking about the power to, the mayor already has to put the person in front of us. We have to vote before, so that is not what we're talking about here. We're talking about interim powers. We're talking about people who are coming in as interim. And we're also saying that if you nominate someone once, you can't nominate them again. Yeah. So we're not saying, the actual power of nominating someone and then requiring city council approval, we aren't changing any of that. That already exists, and that's already the way we're supposed to do business.
But you're asking for that before the employee
No, we aren't. No, we're just saying that employee can't come in and be an interim head of something before they actually get hired by us, because we're the ones that technically hire them in the end. They are nominated by the mayor and then appointed by us.
That still means that the person doesn't have the job that you recruited them for. When I came, before I was confirmed by council, I essentially was in an interim process until I came before council. So that means that I took a job. I was an existing employee, so I would be able to be selected as an existing employee because I started. But you're saying that person doesn't have the job until the confirmation is final. So I'm leaving my current job, taking a new job, and I'm not confirmed in getting that position. I get it, but.
But what happens then if we don't confirm you? I mean, I'm just saying, because we could easily not confirm someone.
I understand that. I understand what you're saying, and there's a process in place. I'm saying, why change it if you have the process in place? To change it any differently, it does not work.
And so I'm just going to respond because it was a response to me, is that the issue was obviously with the last appointment that we had to deal with. I wasn't on council yet, but the idea of us the council not making that decision, and that, quite frankly, the decision was already made, and then council really doesn't get the ability to actually make a decision. And that is, as Councilman Good said, our only opportunity to really make sure that we've chosen the right person. That's basically asking us to fight with an arm behind our back. And I totally see your point, but there's very few ways that we can hold on to the nomination process or the appointment process.
Before I go to Councilman Carlson, Chief, you want to say something?
Just a few points as somebody who's journeyed with you on this. Leaving the interim part out for a second and speaking actually to Councilman Goods, who I know as we were bringing on executive staff, there was a question about the sequencing and the process. And so in other words, the language was in place. The confirmation exists. It still exists, just like Councilwoman Hurtak said. But I think what council was looking for was more engagement before we got to actual game day. And I think what Ms. Travis is saying is that from our side of the HR selection recruitment continuum, and when you get to that point when you make a conditional offer and you start going into background and all those deep sciences, if you will, that candidate is going to make a decision, especially if they're already attached to another executive position and their children in high school and they've lived there 15, 20 years, or whatever, they're going to make a decision. And so I think it really is more about working with council as a process, because when we get to confirmation, it should be just like it was today. It was a 7-0 vote. Everybody was happy. Nicole sent in the resume. She set up meetings. Some people could, some people couldn't, but it was really a good process. And we've learned over time how to dance that dance within the language. So nobody's trying to say the confirmation shouldn't happen or anything like that. I think really it's more incumbent on us to control the process, to make sure that council is fully aware by that time that person comes, and trying to help us work with you to figure out where in that process is safe for the candidate and safe for the city. And so that's kind of the balancing act that I'm using from my experience of working with you in this over 3 years. And it's not easy. There's a lot of dynamics in it. And recruiting is getting harder. You know, we're seeing competition with folks in the $300,000, $400,000 range for jobs that they're taking a cut to come work in civil service. So it's a challenge, but I see it more as working together on the process than trying to change language that may or may not make a difference anymore. So
Well, Chief, that's not my issue. My issue, sir, is, and I'm going to use Mr. Maniscalco, because he was the swing vote on this. And because his exact words was, he asked legal, well, what do we do if this board says no? There's nothing in this charter that says anything on what this council does. Nothing. So if this council goes through the process, you get who you want, but this council says no.
What happens next?
What happens next? So I don't understand how this body as a council can sit here and say nothing is wrong with this process. I have a real issue with that. For council members to sit here knowing that there's an issue with this language and we do nothing. I have a problem with, I'm a policeman. I'm sorry, I go by the rules, John. You know, the rules are the rules. And when a policy is not right, we fix the policy. We're not fixing the policy here, gentlemen. If this council votes someone down The mayor can bring that person back 50 million times from what the last city attorney told us. We have no recourse, but it keeps going back and forth. There has to be a process, a balance, like Chief Bennett says. Where's the balance? How do we stop that? So to me, for this council and councilmen to sit up here and say, nothing is wrong with this, shame on you. I respect you all, but shame on you.
And Councilman Goods, I think to, ma'am,
No, yeah,
sorry.
of course.
I think in response to what you, in response to what I heard after the one particular confirmation that kind of drummed this up, right, was the length of time for council being aware, and so, to what Mr. Bennett was just saying, is the process in introducing the candidate to council and having that opportunity. And each confirmation, I think I probably am the only administrator that has brought you 3 or 4 confirmations in the since this period of time, which is why, huh?
You did it the right way.
But I'm saying, but we learned because we heard what council said about the process, and I didn't do that process independently. I did that process in communication with Chief Bennett, with HR, in saying, okay, this is the feedback that we have. And so each process, so I asked you when we brought Elise Drumgo and Abby Feely to you, and some were saying, well, this is kind of quick, and, you know, so I'm like, okay, I'm learning. So then I bring, you know, the others to you, and we're tweaking and learning. We're constantly evolving the process. And so it's not like, it's not me doing it right, it's us learning through the process and trying to walk that fine line and that balance to be responsive to what you're asking for and the interaction that you want to have with the candidates before a nomination, so. Sorry.
Councilman Carlson, you're going to be next. Ms. Cowan, I saw this look on your face as if you had something to say.
No, I did not.
Okay, Councilman Carlson.
No, we can go around and around. I think we should make a motion at some point and vote on it. But Ms. Travis mentioned, you know, I agree with you 99.9% of the time, but you mentioned a few minutes ago CEO and kind of comparing it to a company. If this was a company, we would be the board of directors. I thought about this a lot. And then we could fire the mayor. We can't do that. So if the crime rate goes up,
yeah.
The budgets get squandered, things don't go out for RFP, city council members get attacked, we can't fire the mayor.
But the citizens
Only
can.
the citizens can do that.
Correct.
So it is a difference. You know, you saw what happened to Bob Chapek. The board doesn't like him, so he's gone. So the other thing is what all this is doing is putting the right words in for what actually happens. If we had disagreed with the person this morning, we would have maybe gone for multiple rounds anyway without this language being changed. But because the process went well and it was a good candidate, it didn't. What happened this one time, and this was with the police chief, is that one reason for the word nominate is to be respectful to the public, because the candidate was presented as the police chief to the public. And I think the reason why I supported this is because it was disrespectful to the public. Not that the person did anything wrong, but just in the person being presented as the final person. Because the public thought, why don't we have any input? Why doesn't the public have any input? And that position happens to be a really important position. And so the administration pushed despite all the community's concerns about things that had happened in the past, and there were promises made that things wouldn't happen again, and so we were pushed. I think it was a 5-2 vote. We'll see whether was a good decision or not, but I think there has to be a collaborative approach. Once these, as Mr. Goods said, once these folks are appointed, we have no power over them. I tried in the charter to change to get us to be able to fire the city attorney, which I think we should be able to. But if city staff, as they are, we've got documents on it that set city council members up against each other or do opposition research on us, we can't fire them. We can ask the staff, the mayor and administration to fire them, but they don't. I hear that more than half of the senior staff don't hit the residency requirement, and so. It's ultimately up to the mayor and how the mayor runs everything, and sure, the mayor's going to be accountable, but the public wants us to be accountable too and to have more scrutiny over these things. And so I think changing a couple words is not a significant change. It only is going to reflect what is actually happening in practice, except these exceptions. And we also have to worry about not whether if you like the situation now between city council and the mayor, you have to think about what if it's even worse. I don't know how it could be worse, but we have to think about that possibility.
God help us.
Thank you.
Councilman Vieira, then Councilwoman Hurtak. Councilwoman Hurtak.
I only have a quick editor's change, Scrivener's error. In the actual charter language, the word section should be capitalized before 6.03 in both instances. So that is my only request.
Pleasure of council.
Do you see that?
That's gonna fail. I'm gonna move it anyway.
Oh, I see what you're saying.
I'm gonna move it. All right, 23. My mind all screwed up right about now. I'm sorry, folks. File number E2022-8CH2. Order been presented for first reading consideration. Ordinance relating to the government of the city of Tampa, Florida, submitting to the electors of the city a proposed amendment to the revised charter of the city of Tampa of 1975 as amended to clarify that the mayor's nomination for heads of departments and other city employees set out in section 6.03 must be approved by 4 votes of the city council, and to provide for interim appointments of existing city employees by the mayor for a maximum of 180 days, providing an effective date.
Second.
We have a motion made by Councilman Goode, seconded by Councilwoman Hurtak. Any further discussion? Roll call.
Miranda,
No.
Maniscalco,
Yes.
Vieira,
No.
Goods,
Yes.
Hurtak,
Yes.
Carlson,
Yes.
and Citro.
No.
Motion carried with Vieira, Miranda, and Citro voting no. Second reading and adoption will be held on January 5th, 2023 at 9:30 a.m.
That was the last one, correct?
No, we have one more.
Oh, okay.
Then we have
I wanted to clarify, if I may, just really fast on that term limits. When we passed that as 4, because Councilman Carlson mentioned something that's true, 4 consecutive full terms, correct?
Yes.
Okay, thank you.
Callaway.
Yes. Okay, on to the last item. And this ordinance before you is amending section 10.10 of the Charter Review, addressing Charter Review Advisory Commission. First thing it does is correct a Scrivener's error, and then it also provides that beginning in 2025 and every 5 years thereafter, there would be a Charter Review Advisory Committee established. Legal counsel, who is not a city employee, would serve as legal advisor to the to the Charter Review Board, and a professional facilitator would be engaged by the city with city council approval. One other item I wanted to just let you know is when we went through these ordinances and it was discussed with both city council, your city council attorney and your city attorney, they asked me whether or not BMO clients had amended the frequency in which their charter review advisory committees meet. And we said yes. In fact, we've had this before. Specifically, the city of Largo several years ago had charter review every 10 years. And then they changed it to every 5. Now, their experience was that, and the feedback that they received from their Charter Review Commission was by the time they had gone through an in-depth review, had everything done, back to their council, and then on the ballot, there was maybe a year break and they were starting again. And so they have subsequently changed it from 5 to 7. So I just offer that as information to you for your consideration, but the ordinance as drafted is every 5 years as directed.
Councilwoman Hurtak.
I know we had debated quite a bit the timing, just because these would have to be amendments to on some sort of ballot. And in hearing every 7 years, maybe we should possibly look at every 8 years just because it would fit the 4-year timeline. 4 years does seem a little soon. But again, either way, I would like it to be in some form of a multiple of 4 so that we can make sure it gets on the ballot with the mayoral and the council elections. Unless we would want to open the can of worms to the other elections, but I kind of like all municipal stuff together.
Mr. Shelby.
No, just for clarification, and thank you for raising that, you can have it at a general election as well. So that would be every 2 years. In this case, the way the deadlines have fallen and the like and council schedule, it's on the municipal election, but it is either choice.
Councilman Goods.
Is the county charter review, they meet, what, every 5 years? Is that correct?
I have not spoken to Brandon Wagner in a while about this. I spoke with him when the Charter Review Commission was first formulated, and he was very helpful to me in the process. And he was talking about the fact, and I haven't verified this, and I can do this and get back to council, but the county's position was that 5 years does seem like it comes up very quickly to them. And they're always almost in a position of going on to the next one. And if he had his druthers, he expressed with me at the time, and I haven't verified that, but I'll just relay it, that he thought that was a very quick turnaround. That was his opinion at the time, and that was, what, 2018, earlier.
Ms. Count, do you know if it's 5 years over there? Would you know? Or Ms. Zelman?
I don't know. I can look it up real quick.
I think 10, in my opinion, I think 10 is too long. I mean, I could possibly with 8 because of the 2 terms, but I think 10 is too long because things do come up, you know, you need to address them. Nothing further, Mr. Chairman, I get it.
Thank you. Your additions or your amendment to this is how many years?
Sorry, I would make an amendment to make it every 8 years. So instead of every 10 years, every 8 years, which actually means that they would start pretty soon, but maybe not super soon. But yes, so yes, every 8 years that, and then which might allow them to do kind of a more in-depth. I felt that, I'll be honest, 13 months wasn't long enough. So if it's a 2-year process and every 8 years, you have enough time. So.
And I would like to, I do agree with you. After a certain amount of time, and let's just say 24 years, that 13 months will get shorter and shorter because each time. And I like this idea because then each council person, whomever they are, can appoint somebody with their ideas, their thoughts, what they like, what they don't like, what they want to see changed, so that maybe the council itself won't have to be doing charter amendments. Yes, Councilwoman Hurtak.
The only other question is just commencing in what year? Please help me with math because I'm still sick.
It's already been 3.
So it says here that it would be commencing in 2025, but I don't know if that math works.
Then
Somebody help me.
30.
No, I mean, it would be 8 years from the last one, which went on the ballot in 2019. So that would be
2028.
2027.
28, I think.
No, 27, because we're up for vote in 23. So it would be up for vote in 27.
I agree with you, but if you do that, it won't be on the ballot at the same time. You have an election, you gotta put it on the ballot, don't you?
Yeah, in 27. So, oh, I see. So you're
See what I'm
saying, duh, do you start the?
You gotta go to the March of the following year, or.
Yes, which would be
Yeah.
2027. So we would start this in 26. So we would start meeting in 26. But honestly, I would still say 25 because I think.
25.
Yeah, because it's a 2-year process. So never mind. We'll leave it at 25. Thank you, though, for helping me with the math.
Okay, who's going to read this?
I will. An ordinance relating to the government of, does this one have, can I read this as is? Because
no.
I can't, because we are changing it.
It's gonna have
Okay.
to change. Oh, I'm sorry, and then I just wanted to answer the question that you had, Hillsborough County, it appears that it's every 5 years.
Okay, yeah, and that did seem a little too much. Okay, so then my motion is just to change it to every 8 years.
We have a motion made by Councilwoman. Can you just at least read the file number for us, please?
Yes, the file numbers, file number E2022-8, Chapter 2. This is dealing with section 10.10.
And that's every
8 years.
Every 8 years. We have a motion made by Councilwoman Hurtak. Seconded by Councilman Maniscalco. Roll call vote.
Hurtak,
Yes.
Vieira,
Yes.
Maniscalco,
Yes.
Miranda,
No.
Carlson,
Yes.
Goods,
Yes.
and Citro.
Yes.
Motion carried with Miranda voting no.
All right, thank you very much. Yes, sir.
Mr. Chairman, if I could just, Mr. Chairman Pro Tem, if I could just follow up on where we stand with this now, why don't you say that for the records of the council?
You have 3 different ordinances that need to be brought back before first reading consideration.
Wait a second, I see somebody, Ms. Cowan, could you just come up here? I just want to clarify, and forgive me, but I'd like to make sure that we are all on the same page, especially when we're dealing with such time constraints.
So as it stands right now, we have item 19, 20, and 23 that needs to be brought back before council for first reading consideration. The next available date to make publication will be December 15th, which is a regular session.
So you could actually bring those 3 back that have passed for second reading on the 15th?
Yeah, the only thing that passed was the changes, not the actual first reading consideration.
Okay, how many, oh, let me see if I understand this now. How many passed that are coming back?
So those that have passed for first reading consideration was item number 18, 21, and 22. So those will be brought back for second reading and adoption on January 5th.
Those passed.
19, 20, and 23 that Councilmember Hurtak requested changes for that need to be brought back for first reading consideration.
And that could be on the,
It can be done on December 15th.
now with regard, yes.
Quick question, then could second reading still be January 5th? Okay, well then, problem solved.
And the question then is, with regard to the 3 that passed, those can't be advertised to come back by the 15th the way things are structured. Is that correct?
No, those were adopted on first reading consideration.
Right.
And is scheduled for January 5th for second reading and adoption. So the 3 that did not pass for first reading consideration
Right.
today will need to be brought back for first reading consideration on December 15th to make January 5th meeting for second reading and adoption, if that makes sense.
Mr. Shelby, it's because the newspaper deadline was the 21st, so they all could fit under the 21st.
My only concern that I have to think through, and I could talk with the city attorney and confirm this, is just the process after the 5th, how long it takes for the mayor to make the decision as to what the mayor's decision is with regard to any of the ones that pass, and then the process for it coming back and in what form or fashion and what date. And that's something that,
We don't have, we don't have control over that.
It's okay.
okay?
Yes.
I see his point.
Yeah, we don't have control over that.
I see his point.
Yes, ma'am.
I'm sorry, I just wanted to confirm, I did hear the reading of the title with regard to section 9.1, which was item 21. Could the clerk confirm that they did read the title on item number 22? I just want to make.
Yes, I do confirm item number 22. The title was read and moved on first reading consideration.
Thank you.
Thank you very much. That concludes the discussion on the charter. We will now go to the consent agenda. First up is Councilmember Vieira.
Yes, sir. Mr. Chair, I move 24 through 28.
We have a motion from Councilmember Vieira, second from Councilmember Hurtak. All in favor? Aye. Any opposed? Councilmember Goods, you are the chair of Parks, Rec, and Cultural Committee.
We move items number 29 to
Second.
We have a motion from Councilmember Goods, second from Councilmember Moreno. All in favor?
Aye.
Any opposed? Councilmember Hurtak, you are up next.
Yes, I move items 31 through 38.
We have a motion from Councilmember Hurtak, second from Councilmember Vieira. All in favor? Aye. Next is the Finance Committee. We have some that we've already voted on. Councilmember Miranda, yes,
Think,
sir.
with 39 and 41 were taken care of, from the 40, 42, and 43.
We have a motion from
Second.
Councilmember Miranda, second from Councilmember Hurtak. All in favor?
Aye.
Any opposed? Councilmember Carlson, Building, Zoning, and Preservation, 44 through 53. We have a
Second.
motion from Councilmember Carlson, second from Councilmember Hurtak. All in favor?
Aye.
Any opposed? All right, items 54 and 55 are review hearings that need to be set. Do we have a motion to set
Motion
those
set the hearings.
We have a motion from Councilmember Goods to set 54, which is for February 2nd, 2023 at 1:30 PM, and item 55, which is scheduled for February 2nd, 2023 at 1:30 PM. Second from Councilmember Miranda. All in favor?
Aye.
Any opposed? All right, can I get a motion to
So moved.
open item number 56?
Second.
We have a motion from Councilmember Goods, second from Councilmember Hurtak. All in favor?
Aye.
Aye. All right. Now that we have these hearings open, can I get a motion to remove item 57 from the agenda?
So moved.
Motion from Councilmember Goods, second from Councilmember Miranda. All in favor? Aye. All right. This is the last item of this agenda for this morning that has gone into the afternoon. Ma'am, would you like to present? Oh, if anybody that wishes to speak on item number 56, please stand and raise your right hand, and we will swear you in. You want a 5-minute recess? We're going to swear you in. We're going to have a 5-minute recess.
Do you swear or affirm that the testimony that you're about to give is the truth and nothing but the truth? Thank you.
All right, we are in recess for 5 minutes. We'll be back at, let's say, 3:45. Thank you.
VRB case 22-70 for the property.
Mr. Chair, I'm sorry, should we, since we only have 4 people here, should we ask the applicant, before we spend a lot of time on it, should we ask the applicant if they're okay with 4 people, or do they want to, what do they want to do about it?
Well,
Do you wish to have a full council, or are you fine with 4 people?
and I can see how many people, there may be people who are, I know Councilman Chair Citro is not coming back.
Citro is gone for the day.
Hurtek is in the
and
back.
Hurtek is coming back? Okay, we have 5 members, and Vieira will be here, so.
So we have 5 now, maybe 6, but, so are you comfortable with that? 4, you'd be able to, if you wanted, under the rules, a continuance, you'd get it as a matter of right, but now we have 5, so it's pretty discretionary, it's your call. Ultimately, it's council's.
Jamie Mayer with the law firm Hillward Henderson, representing the applicant. If it's all right, I'll just talk to the client for 1 minute to discuss. Although, just to confirm, Councilman Vieira will be returning, or he's also
Yeah, he's here.
gone?
His keys are here, so.
He's
not
gonna be back.
Yeah.
All right. I'll just, if you don't mind, just.
Unless he Ubered out of here. Go ahead, please.
Sorry, I just wanted to make sure we did that before we went through the whole case. We only had 4 people, so we asked them if they were okay proceeding.
Yeah, I apologize. I didn't know how the hot water worked. So I ended up having to microwave. No, you didn't. Yeah, I microwaved my tea instead. Now I know. Now I was taught how the hot water works. Well, you have to pull it instead of. Anyway. Yeah.
Motion to add in the budget, money for a tea kettle.
Well, you just taught me something, and I've been here 3.5 years.
Well, I had to ask because I said I was told hot water works.
What about the hot water and the coffee? Isn't there an option just for the hot water?
There is on the water cooler.
Okay.
And I just didn't know how to use it, and now I do.
Yes, ma'am.
We're happy to go forward if, once Mr. Vieira gets back, if that's okay, or just move forward now and he'll be here for the voting process. We just want to have as many folks on the board or on the council as possible, if that's all right.
Okay, so we'll begin the presentation and.
Sure. Staff's presentation, I think?
Yes.
Yes, ma'am.
Yes, please.
While she's handing out the packets, Kamaria Pettismackle from the legal department, from the city attorney's office. Again, I'm here on behalf, regarding item number 56, which is VRB, case VRB 22-70 for the property located at 3122 West San Jose Street. There was a petition for review that was filed on the behalf of the, on behalf of the applicant, who is Mark Mobley. He owns Mobley Homes Customs LLC, and Ms. Meyer is here representing him as his authorized agent. The request that was made to the Variance Review Board was regarding approval to remove a grand tree. The Variance Review Board heard the request and held a public hearing on September 13, 2022, and denied the request to remove the grand tree based upon the applicant not meeting the standards set forth in Code Section 27-284.2.5, subsection F4. I previously handed City Council, or provided City Council, the relevant code section, which is Code Section 27-61, subsection J2A, that provides the parameters in which City Council can conduct a review hearing, and also the relevant Code Section 27-284.2.5, which are the factors that City Council has to consider in whether or not to grant or deny a request to remove a grand tree. As previously stated in Code Section 27-61, subsection J2, the standard of review for this matter is a de novo standard of review. City Council, which means City Council shall not be limited in its review to the information or documentation or evidence upon which the board based its determination. There are 2 staff members present who will provide an explanation of the decision from the Variance Review Board and what the application was. Those staff members are Jane Madu and Stephen Iser from Natural Resources. After City Council hears, hears all the evidence in the case and all the documentation, City Council can take 3 actions after, at the conclusion of the hearing. City Council can affirm the decision of the VRB in case VRB 22-70 and deny the request to remove the grand tree. City Council can remand the matter back to VRB with direction. Or finally, City Council can overturn the decision of the Variance Review Board in case VRB 22-70 and thereby grant the request to remove the grand tree. And with that, I will turn the presentation over to staff.
Thank you very much.
If we can, Mr. Chairman, before you begin your presentation, just if there have been any ex parte verbal communications, please disclose them if there are any that need to be disclosed prior to this hearing continuing, and also just a motion to receive and file the written ex parte communications.
We have a motion from Councilmember Vieira, second from Councilmember Goods. All in favor? Aye.
Thank you.
Any opposed? Thank you. Yes, sir, go ahead.
Hello, Stephen Eister with Natural Resources. I have been sworn in. This is the recap. Here's the property information. The property owner is Mobley Homes Customs LLC. The applicant is Mark Mobley. The address is 3122 West San Jose Street. The zoning is RS60. The variance requested is to remove a grand tree to construct a new single-family residence.
Key and I, if they could put this on our screen, we all we see is a construction cone. There we go. Thank you.
Oh.
Yes,
Here,
sir.
we'll go back to, there's the property info, so you guys can see that.
Yep.
This is the standard review for variance for grand tree removal. If you guys want to read through that. So it's broken into 3 sections, A, B, and C, and it covers the building area, the proposed building, reductions in setbacks, alternative construction methods, the cost of utilizing any alternative construction methods, and then you can consider the existing developments that are around. This is the variance board's decision, like Kamaria just covered. The variance review board heard the case on September 13th. After the testimony, it was denied 5-1 to remove the grand tree. The lot is in the South Tampa Planning District. You can see the overview of the lot. This was the existing home on the lot. That house was demoed back in just a few months ago after Mr. Mobley purchased the lot. This is the new proposed home. A design exception was applied so he can construct the home to the 20-foot setback in the front and then the front porch. These were the 2 alternative designs showing a front loading garage and a side loading garage. And then it's in the L shape to move it out of the 20-foot protective radius of the grand tree that's in question. These are some photos of the tree, just so you guys can kind of see the overall size. The DBH of the tree was 43 inches. The canopy spread was 57 by 66. And the rating on the tree was B6. And then if you have any questions.
Do we have any questions for the gentleman? Nope. Thank you very much, sir.
All right, no problem.
All right, do we have another member of city staff that is going to be presenting? Or that was it? That is it? Okay. Next up, we have the applicant.
Good afternoon. Again, Jamie Mayer representing the applicant from the law firm Hillward Henderson, 101 East Kennedy Boulevard, Suite 3700 in Tampa. I have been sworn. I have a PowerPoint as usual, and I know it changes sometimes who I'm supposed to give it to. So if I'll try here, I guess. And, oh, okay. Right. But, yep. Thank you. Alrighty, that was easier than last time. I also have with me here today Mr. Ricky Petarica from Dark Moss LLC, who will be providing testimony. I have submitted a copy of his CV into the record and request that he be accepted as an expert. Before he provides testimony, though, I would like to just walk you through some more background, in addition to what staff has provided, and to discuss in a little more detail the reason we're appealing this decision. So again, as you saw, the decision appealed was a decision of the Variance Review Board to deny a request to remove one grand tree for the construction of a new single-family residence in the RS60 zoning district. The proposed new structure is 2 stories. That is permitted in the RS60 zoning district. The setbacks with which the tree directly conflicts are also those that are permitted in the RS60 zoning district. So the issue is that the location of the tree on the site is directly within the buildable envelope that is permitted by the zoning district. As you can see from the aerial, the site is heavily wooded. It's actually probably got the most trees generally on or around it out of the entire block. Now I want to be clear, there are a number of trees, like I said, on and around the site that affect the site. The only one being requested to be removed, I'll show you in a couple slides, and you've already seen from Natural Resources, but I wanted to show you the other trees that will remain on the site. So this is not going to be raised. There's going to be trees remaining on and around the site. For lack of a better term, I've named them tree A, B, and C, and have labeled them relative to the site plan. This tree is along San Jose Street and is going to remain. Tree B is in the rear corner of the site and will remain. And tree C is on the side, kind of to the rear, along Esperanza and will remain. I do have another more close-up for you, but I wanted to, I point out here the tree, the removal tree, I'll call it, standing from the street on San Jose, and you can see the number of other trees that will remain. Again, it's clear that from the site plan, this tree is within the buildable envelope. So this tree is located pretty centrally to the site. Again, what you're looking at, what you see, is part of the by right building envelope, that a structure that is proposed here could be built on under the zoning. And the canopy takes up a lot of the site as well. So although, as Ms. Pettis-Mackel pointed out, this is a de novo hearing, I want to talk about the reason that we are appealing to you to achieve a different result. The Variance Review Board did err in multiple ways in its decision making. There was a lot of talk, and they ended up relying on, in large part, the outdated tree code standard, using the term reasonable use. That is not even in the current tree code anymore, that term. And it was used, and many of you are probably familiar with it because this change was in 2019. But it was used throughout this hearing, and it was blended with the current code that applies. But the current code uses the reasonable reconfiguration standard, which Mr. Petarica will do a better job of walking you through than I would. But they misapplied that term as well, and we'll show you how. Ultimately, they also relied on inappropriate bases for denial that were not rooted in the code criteria which they were required to apply. Now, the current code is designed purposely to be objective, but by blending the old code and misapplying the new code, they reached a totally subjective result. Our firm was not at the Variance Review Board hearing. However, when we reviewed the transcript and saw how the code had been misapplied, the first step was to ask Ricky Petarica, who better to ask because he was very involved in the transition of these codes, and he's applied them both. So his testimony will be invaluable. Again, to reiterate, the code was overhauled in 2019 to create an objective process. There were even workshops held, training city board members or sitting board members how to apply it because it was such a different result. Again, the old standard was subjective. It was more focused on any conceivable structure that could be built on the property. In this case, it would be a single-family home, but any conceivable configuration or size of that structure that you could work around the tree, that could be considered a reasonable use under the code, and the tree would have to remain. The new structure, or the new standard, is objective, evaluating the actual structure that a given applicant has proposed and asking, can this structure, not any conceivable structure, but can this structure be reasonably reconfigured, and I'm using quotes here because that is a defined term in the code, such that it could save the tree. And the term reasonable reconfiguration is not a subjective standard. It is clearly defined. It either is or it is not. And I'll turn it over for a few minutes first to Mr. Pederica to explain that.
Thank you very much. Yes, sir.
Thank you, Council. Ricky Pederica, 308 East 7th Avenue. I've been sworn. There are 5 criteria for green tree removal, Table 284.2.5. The 2 that apply most closely to this case are the small lot criteria, the TRZ, and green tree removal by commission or construction activity impact reviewed by commission, which is the VRB or your body. Small lot criteria would apply to the lot, but not to the tree because it's not located in the TRZ. So which is why they went to the VRB. So they're subject to the other construction activity impact criteria, which is shown on the slide, but the main component that I'm speaking to is on the bottom, no other reasonable reconfiguration of the development. So that is defined in footnote 5 of Table 284.2.5, kind of 5 bullet points. If these things can be done to the building footprint as proposed, then it shall be considered, basically, it shall be considered reasonable. Otherwise, it would be unreasonable. So it does not adjust the structure more than allowed by the design exception. So not more than 25% front or back or 1 foot side to side. Does not change the number of stories proposed. So it doesn't go from 2 to 3 or 1 or 2 to 1, and does not adversely alter internal flow or function of the proposed structure, which is a very flavorful statement on what internal flow and function is, but I've always interpreted it as, is this the same program of the building that we're proposing, if just a different shape? Or did we lose elements of the building for tree preservation? So like I said, the design exception does not shift the building far enough outside from causing the tree or the building to be preserved, or the tree to be preserved without the building footprint being affected. So it doesn't meet the design exception adjustment. 2 options were proposed at the VRB. Both basically notch out a quarter of the building, and this is which is shown in red, which is approximately 30% of the building's gross square footage lessed out to accommodate tree A, which I evaluated as tree 1, and determined to be a 43-inch tree, B6, non-hazardous grand tree in agreement with natural resources. So there's no dispute about the condition, just about what reasonable reconfiguration is. So both of these examples, we lose, or 30% of the building footprint is lost to the tree preservation commitment, which is addressed here. And additionally, by showing the floor plan of the building, we can better understand, of the proposed building, better understand what actually is lost from the internal flow and function, which in this case, the master suite no longer has a master bath or closet. So the stairs are affected, which could affect the second floor. And it gets a little potentially esoteric as we apply this, but I think at the easier review is this the same building that was proposed? Could it just be moved on the site and accommodated? No. Could it be increased in floors or decreased in floors without losing square footage? No. So by those criteria, we, in my opinion, it's no longer reasonable reconfiguration. This was proposed by staff, this option, which is a slight hybrid of what was proposed by Mr. Mobley, but it locates an accessory structure for a garage. In my opinion, this is technically unreasonable reconfiguration because we've lost the 30% roughly of the lot area and by literally breaking the building into two. And all that's been broken off is the garage. So this proposal from staff during the hearing, in my opinion, was an example of an unreasonable reconfiguration option.
So just to summarize, and thank you, Mr. Federica, for your testimony. So you've heard how the factors that the board was required to consider, and you've seen them in the standard that was provided to you by the city attorney, I'm sure, in your packets. The board was required to consider factors in the code, such as the impact of the proposed structure on the tree. Well, it's, as you've seen, would be going right through the trunk. Obviously, that just cannot coexist. Whether it can be reasonably reconfigured, as that term is defined in the code, whether the setbacks could be reduced to preserve it, whether alternative construction or the cost of that alternative construction could preserve it. And you've heard in Mr. Federica's professional opinion that those factors weigh in favor of removing the tree because these potential fixes that the code suggests and recommends or requires the board to consider don't work here. Now, instead of considering all the things that it was supposed to consider, and ultimately what it made its decision on were things that they should not have considered. Again, they discussed at length and asked questions of staff, the reasonable use standard, saying a home is a home. Any home, suggesting that any home, including the 1,000 square foot home that was there before, was very small, completely different, has been demolished, was reasonable use. Under the old standard, that probably would have been the result, but that is not the standard any longer, and that was a conscious decision to change the code. It is unrecognizable from the standard that existed in 2019 and prior. And also, as an express reason for denial, when they listed their reasons for denying the application, they expressly stated that the number of speakers and letters in opposition could not be ignored. That was a reason for denial. There is well-established case law that says a large number of residents opposing or appearing to object is not a valid basis for denial of a permit. And they still use that as a basis of denial of the permit. In summary, you've seen how this structure cannot be reasonably reconfigured. Again, as that term is defined in the code, it is not subjective. It is not anybody's idea of what reasonable could be. The dictionary definition of the term, it is a defined term with criteria, and you've seen how it cannot be reasonably reconfigured. Therefore, the structure that is proposed on this small lot where several trees are at issue, this particular one is centrally located. It is located within the buildable area that is created by the zoning code. The application of the correct code standard would have resulted in an objective finding that the tree must be removed. Therefore, we respectfully request that City Council apply the correct code standard and reverse the VRB's decision. Thank you.
Do we have any questions for the petitioner? Hearing none. Madam Clerk, do we have any registered speakers for public comment on this or no?
Yes, we have a speaker.
We'll take the registered speaker first and then we'll go to the audience. Go ahead. If Stephanie Pointer is on the line, unmute yourself and be ready to be sworn in if you haven't.
She's on.
She's on?
Mm-hmm. She just need to turn on her camera and unmute herself.
Ms. Pointer, if you can turn your camera on, we'll swear you in and begin public comment. There she is. Well, there's the camera. Other way.
There she is.
All right. If you could be sworn in and unmute yourself.
Ms. Pointer, you're unmuted on the platform, so you may need to unmute your device.
He just threw us a full show.
You're still muted. You're still muted. Ms. Pointer, we'll come back to you. We'll start the public comment that's in the room, so just stand by. All right, if you're here to speak on this item, please line up if you are able to, and you will have 3 minutes to speak. Please state your name before speaking. Thank you. Yes, ma'am.
Good afternoon. I'm Mary Lee Motto, and I have been sworn in. I'm a graduate of the Mayor's Neighborhood University Class 10 of 2018, member of Palmacia Neighborhood Association, and a registered member of the City Emergency Response Team, but most importantly, I built a house 3 properties away from the property in question. It's my first time in front of y'all. I'm a little nervous. This tree is very important to me. It provides important and impactful shade for our neighborhood. It provides my dog's paws with that shade as we walk them through this neighborhood. It's one of the largest trees in my community. I believe the removal of this tree would cause my family direct harm in the form of diminished property value due to reduction of the visible tree canopy, the neighborhood charm that I spent the money to build my house in, and the available shade to walk my dogs in on severely hot days in Tampa. Our tree canopy is critical to keeping our temperatures down. Please help protect the tree canopy of our city. According to the arborist report, this tree would have to be replaced by 16 trees, 16, to get the value it provides and the impact available from it today. Of the 42 property owners listed in the petition for review of the VRB decision document, I personally contacted the following property owners today and have authorization from each of them to enter their name on record as being opposed to the removal of this tree. Caroline Carrie Martin Fowler, Mary Ellen Walker, Doris Ann Plath. In addition, Nancy Bryant is a homeowner in the neighborhood and authorized me today to enter her name as opposed. Megan Leibel is also granted me authority to enter her name on record for this agenda item as being strongly opposed. She is resident property renter immediately adjacent to the lot and has emailed her strong objection as well. It is posted in the supporting materials for this agenda item. In their comments to me, Megan and Nancy confirmed that the property owner of 3119 West Palmyra, Sharon Hickenbotham, is opposed to the removal of the tree as well. I thank you for your service to our city and for your attention.
Thank you very much. Yes, ma'am. Next speaker.
Thank you.
Thank you. Yes, ma'am, go ahead. Please state your name.
Hi, my name is Carol Ann Bennett. I'm a lifelong Tampa resident. Several years ago, the building community was fed up with the Tampa Tree Code. They wanted to look at a property and know what they could build. They needed predictability to evaluate their purchases. So for a year and a half, Tree Something Say Something and builders and city council worked together to write a new Tampa Tree Code. I am here today asking you to uphold the code that you and I and the builders wrote together. We tree advocates made a huge compromise and agreed to a large tree removal zone on smaller lots, the TRZ. We agreed that a tree in the buildable footprint of a smaller lot can be cut down and we wouldn't find it. These are approved administratively. We sacrificed the trees inside the TRZ to save the trees outside the TRZ. But if builders can cut down those trees too, then what did they give up? What happened to their compromise? We negotiated in good faith, and I believe City Council negotiated in good faith when they unanimously approved the new tree code. All the stakeholders compromised to achieve predictability so that time and resources aren't wasted. And yet here we are again, wasting time and resources. This tree is not in the TRZ. It is a very healthy, B-rated tree that will live for centuries. There was a normal-sized house in good condition on this property. Multiple people testified to the VRB that they would have loved to buy and live in that house for the $515,000 that Mr. Mobley paid for it. But they never got the chance because it never went on the market. So they are still looking for a home. Arborist David Riley evaluated this tree before the sale. The buyer knew it was a very healthy grand oak that was not in the TRZ and could not be removed. There are very specific criteria you must consider. Your decision boils down to this: can a home be reasonably configured on this lot without killing this grand tree? The answer is an obvious yes. The city arborist thinks it can be saved just by having a detached garage and using some of the pier and lintel construction. This property is on the market in a pending status as a 6-bedroom, 4-bath, 3,515 square foot house with a price tag of $1,599,000 on a 50 by 100 lot. A new house can be built there without damaging the tree. It might need to be smaller than 6 bedrooms, but that sounds like reasonable configuration to me. We have a tree code that told him he could not remove this tree. The VRB evaluated the criteria and voted 5-1 that he could not remove this tree. Please uphold the VRB ruling and deny the variance. If everyone knows the city is going to enforce the tree code that the stakeholders wrote, people will start building the right thing in the right place, and your time and resources won't be wasted on variances and appeals, and you will give builders the predictability that they demanded. Thank you.
Thank you very much. Next speaker. Yes, sir, please state your name.
Bob Whitmore with City Tree. I'm going off script. I'm going to use the force fluke. This is what happens. You know, experts come in when a builder wants to build on property that is in the way with a tree that's in the way. I'm going to bite on this reasonable reconfiguration issue. This is a courtroom right now, and you guys have got to make a decision. You don't want to hear about sparrows, squirrels, and tree huggers. You want to hear about a fact. Mr. Mobley has 3 models. That's what people can pick out of his configurations. There is nothing that is custom about Mobley Custom Homes. He will go in, he will mow down whatever has to be taken down to put his boxes on that property. He did not try to reasonably reconfigure this house. A Sharpie marker sketch over old plans is not reasonable reconfiguration. Mr. Mobley, in the VRB, admitted he has no architect on staff. He has nobody that can go in and say, you know, Mr. Mobley, if we just shift this over a little bit, maybe we can save this tree. It's not there. So he can't do it, and he's not going to spend the money to do it because he knows what it costs to build a house on this property with the amount of materials that he used for every other single property that he is plopping down on pieces of land throughout South Tampa without even giving any consideration for design and looking at things that actually sort of fit with the neighborhood. He's in it for the money. He's building boxes people will buy for hundreds of thousands of dollars. He doesn't care about what people can afford. He knows his market. He knows that people can buy his houses, and he's putting them up. And what is he taking away? He's taking away, Mr. Morati, you talked about you don't want to give away water. He's taking away air. He's taking away shade. He's taking away, we are selling that to the highest bidder. And Mr. Mobley is one of the worst offenders for getting that and giving nothing back to the city of Tampa. He is looking to make money. He wants his way. The VRB said they could not have his way, and they said why he could not have his way, and there's a lot of smoke and mirrors and just throwing some verbiage up. You guys aren't going to have time to look into that. The fact is, the VRB said, look, you can put this up. The tree is this far away from where the envelope is. Maybe you can fix it so that you can go ahead and build a house there. Doesn't want to do it. Too much trouble. So he brings a lawyer and he brings an expert and he goes ahead and he throws it out in front of you guys and he's going to play you. They're going to play you. And I hope they don't. Thank you for your service.
Thank you, sir. Next speaker, please. Please state your name.
Alejandra White. I live in San Jose Street, and I've seen how my block has changed and the trees are gone. And I don't want to allow this to, I don't want to see this happen again. Thank you.
Thank you very much. Next speaker, please state your name. Yes, ma'am.
Caroline D. I'm a Palmacy resident. This morning, I walked by the tree in question 2 blocks from my house. My husband and I often walk by in the evening and enjoy this beautiful oak. It would be a great injustice to cut it down for another giant house that goes from lot line to lot line. This tree is in what would be known as the backyard of the lot, when there were such things as backyards. It's not centrally located, as they have said. It's towards the back, it's towards the side, it's in the backyard. The developer, Mr. Mobley, could build around the tree, but that is not what he does. He has his house plans, and the lot needs to conform to his cookie cutter houses, not the other way around. It creates a hardship for him because it might interfere with his bottom line. The council would do well to consider also the hardship to the neighborhood and the community by the destruction of another grand tree for Mr. Mobley's bottom line. Just months ago in our neighborhood, again just down the street from my house, we lost a beautiful grand oak for one of Mr. Mobley's houses. He is a frequent victim of hardship at City Hall, but I am hoping that today the council will consider the hardship to the neighborhood and the planet and listen to the Variance Review Board and city staff who have wisely recommended that this lovely tree be saved.
Thank you very much. Next speaker. Yes, ma'am, please state your name.
Can you see this?
Yes, if we could activate the overhead. It's still showing the PowerPoint on, okay, now we can see him. There we go. Yes, ma'am. The bottom picture is off view. No, those pictures are fine. It's that single bottom photo is out of view. There we go. Thank you.
Before I begin, I'd like to know if I could show you all a 18-second video of the tree. I talked to Tom D. ahead of time, and he said I'd have to ask you.
That's fine with me. Any objection from council? No? Who has the video? Did you hand over a...
He has it.
Okay, if you could play the video. There we go.
Okay. Good afternoon. My name's Lorraine Perino. I live in South Tampa. I'm president of the Tampa Tree Advocacy Group. On July 7th, 2022, the National Weather Service issued a rare warning to Tampa residents to exercise caution while outdoors, as the heat index that day would make the 93-degree temperature feel like 110 degrees. Despite the climate change alarm bells going off daily, Mobley has petitioned the city to rescind the VRB's decision and instead allow him to destroy one of Tampa's most essential, valuable, and beautiful trees, a healthy 50-foot tall grand oak located outside of the buildable area, to build a larger structure than the city code allows. Is this the behavior of a good corporate citizen, or is it greed? The builder asserts that removing this grand oak would allow the property to be used in the same manner as other lots in the same size in the same area. However, other lots in the same size do not contain a healthy 50-foot grand oak growing on them. Note that the city arborist plan proposes an alternate design which would preserve this old growth grand oak for future generations to enjoy. Mobley admits to purchasing the property with the tree on it, yet astonishingly claims that the grand tree has created a hardship on him, and even though the tree is protected by the city's tree ordinance, he figures he can beat the system and destroy the tree by appealing to the city. Removing a tree of this size against the wishes of the neighborhood residents would also negatively impact their health, as the loss of shade and cool air that the tree provides would cause the heat index to rise dramatically as referenced above. The grand oak's removal would also increase air pollution in the neighborhood, resulting from the release of CO2, which has been stored in its trunk, and the CO2 which it would cease to capture. The neighborhood would also be deprived of the tree's beauty and the pure oxygen which it pumps out daily, and songbirds, squirrels, butterflies, and all wildlife dependent on this grand oak would be negatively impacted. Despite these serious consequences, the builder falsely asserts that by removing the tree, the rights of others are not compromised or injurious in any way to the public health, safety, and general welfare. Mobley Homes cares only for its own selfish interests, not the good of the community. Mobley claims that the proposed variance is in harmony with Tampa's comp plan. However, the comp plan's urban forestry section states, tree canopy is a vital community and environmental asset that is appreciated and desired by residents in new and established neighborhoods alike. The protection and supplementation of this tree canopy is a necessity in order to sustain the resource and maintain the environmental benefits such as cooler temperatures that the mature canopy provides. The 2011 urban forest analysis states, unlike other public infrastructure components, properly planted and maintained trees increase in value over time. It's past time to stop catering to the selfish desires of builders by not allowing them to destroy Tampa's old-growth trees and negatively impact our own health. Instead, let's preserve Tampa's grand trees and cherish them for the beauty, health benefits, and quality of life that they provide for us at such a minimal cost. Please vote no to the self-serving appeal and vote to preserve one of Tampa's most beautiful old-growth grand oaks for all of Tampa.
Yes, ma'am. Thank you very much. All right, next speaker, please state your name.
Good afternoon, Carol Camisa, Palmacia. I've been sworn in. I'm also a dog granny, and I walk in this neighborhood and enjoy the shade, the beauty of the tree, the brick streets. Mr. Mobley has claimed that one of his 3 models that he intends to put there will not change the character of the neighborhood. And looking at those pictures and my own walks there, I would disagree with that strongly. In my dog walks, I also see other properties constantly being developed in South Tampa. The lots that have a Mobley sign on them generally are ones that are flat, treeless, and can accommodate one of his 3 models. There are other developers, and I'm not here to promote or not any particular developer, but I see places where trees are roped off and tractors move around and that kind of thing. It is possible to have a reasonable accommodation. This is a smaller lot, but that's not the modus operandi of this particular developer. And I don't think that, given the strength of the community's feelings and case that they're making about saving this tree, someone pushing a waiver through the system just because their business model doesn't accommodate this particular lot and this particular tree is a good case for a waiver. So I would ask you to deny that request. Thank you.
Stephanie Pointer, are you unmuted? Is she logged in still?
Ms. Pointer, just turn on your camera and unmute yourself, please.
We apologize, but there seems to be some technical issues, so at this point...
Can you hear me?
Yes, ma'am. Turn your camera.
Okay, let me see. Can you hear me?
We can hear you, but we can't see you.
No worries.
Okay, thank you very much. That concludes public comment. We'll go to any additional staff comment, if there is any. Yes, ma'am?
Good afternoon, Jane Matter Development Coordination, and I have been sworn in. I would just like to provide the council with further clarification regarding some of the things that the legal representation for the applicant brought up. She did mention, she talked about reasonable use or reasonable reconfiguration as the discussion that went on during the VRB hearing. Ultimately, the decision of the board was based on section 27-284.2.5 F. And that is the parameter within which the board has to decide whether or not to approve a grand tree. And they did talk about reasonable use as to the fact that there was a house previously on this property. And the applicant did say that it's impossible to put a home on this property without removing the tree. And that was how that conversation went, in that there was actually a house and the tree was there. She did talk about the fact that, and I think it was the expert that spoke about altering the internal flow of the structure or the proposed design. Again, that section says adversely altered. So if you're altering the internal flow in a way that you cannot function in the house without, in the way that you have to alter the house, then it's adversely altered. It doesn't say you cannot alter the flow of the internal structure. They did provide alternative site plans, and I've been doing the variances for a little bit. I've seen private homeowners submit alternative site plans that show that they're actually trying to preserve the tree. That is the whole idea behind alternative site plans, that you show us that you're trying to see how this tree can be preserved. With the site plans that the applicant provided, their legal representation said that the site plans show that this tree cannot be saved. What the applicant did provide to us is the proposed plan with a cutout of the section of the radius of the tree. Unfortunately, we don't see a lot of creativity or even the intent to reconfigure, because you're basically giving us the same thing without actually massaging this plan. So, and we, as staff, we take what you give to us. We can't say this, we would reject it because the alternative site plans are your, whatever you choose them to make them. But we see a lot of plans where the applicant is really not trying because they feel they don't want to put an effort to save the tree. But we see these site plans. Part of what the code says is that your alternative site plan should account for the provision of the code to reduce your setbacks to save a tree. And that is in section 27-284, the section that the board has to look at, and it says in C, whether the reduction of the required setback for the primary building or structure as provided in section 27-156, we allow the relocation of the building sufficient to preserve the guarantee requested for removal. In the alternative site plans that the applicant provided, they did not account for those setback reductions provided by the code. So they are not looking to see how this could, and they could get a lot of, latitude with, if they did take consideration of those setback reductions to save a guarantee that the code has provided. The other thing is that they did mention the proposal by Natural Resources in his proposal for how they could massage this building. What he did was based on the alternative site plans that they provided. That was not his proposal. So when they say that the Natural Resources proposal failed or would not be feasible, he was just working off of what they had already provided to us and saying, if this is what you're looking at as an alternative, there are ways to make this work. During the hearing, I believe it was, and I can be corrected if I am wrong, I believe it was the board member, Una Johnston, who posed a question to the applicant to say, would you be willing to consider alternative construction methods in order to save the tree? And his response to that was no, he declined. That is one of the requirements in the section that says in E, the cost of any alternative construction methods or reduction in the use of the proposed structure. He was not willing to even consider alternative methods, even though with a pier and lintel construction, you could encroach into that protective radius. So the last thing I'll say regarding what they did say is about the zoning setbacks and the buildable area to say that what they are proposing is within the buildable area. Correct, you're within the setbacks for your zoning. However, we do have a code that protects grand trees. So our zoning setback does not negate the fact that we have a tree that is protected by the code. The code doesn't contradict itself. So we have setback reductions in order to save the grand tree. So yes, you're within the setbacks, but we also have a code that we have to respect that protects the grand trees. So when you come on the site or you come into construction, we consider how you are treating that site in respect to the code. So yes, you are within your building envelope or what you could potentially build on that site, but we are giving you allowances within the code to move your building in order to save the grand tree. And so those were the comments that I just had in response to stuff that the legal representation for the applicant had said and to what their expert witness had said. If you have any questions, sure.
Have you seen this report by Hill Ward Henderson that was provided to council?
No.
So I can't really ask you questions. From what I'm seeing, I'll ask the applicant, I guess their chief complaint is saying that our variance review board erred on the terminology or the interpretation of reasonable configuration. But since you have not seen what they briefed, I'll have to wait till they come back to ask them that question. Maybe you can come back after that, since you have not read what they've submitted.
Well, I kind of try to address part of that question of reasonable reconfiguration in saying that one of the things, or part of what they had highlighted, was the fact that if they were to, change the layout of what they're proposing, it would affect the internal flow of the building or internal flow of the design. And I'm saying that what that part of the code says is adversely alter. So if you have to change this in a way that you cannot function within the building or within that design, let's say you cannot get from your living room to the bedroom, or it affects that, then it's adversely altering the internal flow of your structure. That we don't see by what the applicant has provided to us.
Okay.
The other thing that they said, we're not proposing any changes to the height of the structure or what they are proposing. Yes, there are low-hanging branches, but our natural resource expert can speak to the fact that, you can have tree pruning and all of that, that would still preserve the tree and allow them to build what they're proposing. But those were part of the things that they had mentioned regarding reasonable reconfiguration, and I'll allow Stephen to answer any questions regarding the technical aspects of, pruning that tree and if they have any other things, I can come back up to address that.
All right, if there's no other questions at this time, we have rebuttal from the applicant. 5 minutes rebuttal. Yes, ma'am?
I want to address a couple of things first that were said by staff. The applicant did not say that. Actually, I think I'll have the applicant himself speak to the alternative construction. I want to clarify actually a few things that were said by everybody. Mobley builds a lot of homes in the area, and he frequently builds them around grand trees. He does that. That is a fact. And also, he is a builder. There are contract purchasers to buy this home. They live just down the street. They want a bigger home. So for what that's worth, there is there's a living human being behind this who lives on the street wanting to buy the home for whatever that's, worth. And I think it is worth something. I'm going to have Mr. Pederica reiterate how the code applies here. But what staff is saying is, again, not applying the reasonable reconfiguration analysis of code. These grand tree removal cases get approved a lot since 2019. You don't see them because they typically are applied correctly. There's typically not as much public comment, frankly, as there was at this one, because it is easier, frankly, to remove the grand trees now under this code because it is objective. That was the whole purpose. And saying the TRZ is what dictates everything. No, the TRZ is a way to remove a tree without having to get a variance based on a defined area of the lot. And then the code says, if the tree, which this tree is 8 inches outside of that, if the tree is outside of the tree removal zone, okay, then you have to get a variance. And here are the criteria that you apply to get that. Basically saying, well, because you have to ask for a variance in order to remove this tree, that's why it should be denied. Why would we have that at all? Why would that process exist? The process is there if it cannot be removed because of the TRZ. And Ms. Federico, if we just clarify again, the reasonable reconfiguration analysis, can you just read the criteria, or at least summarize them? I know the criteria have been in front of you.
As applicable to this lot, in many lots, the reasonable reconfiguration criteria asks someone to take their proposed footprint, either A, shift it to the design exception setback, 10% to the front or the back, that would be 2 feet. 25% to the side, 7-foot side setbacks, maybe there's a corner setback that applies, barely a 1.5 feet. The tree is currently located about 7 feet from the 7 feet from the property line at the side setback. It's in direct conflict with the proposed building wall. The tree trunk is in conflict with the building wall. Not the branches may also be in conflict, but if we're cutting off an arm at your chest, the arm's less the point. There's no change in stories. I don't think that's really an issue, except that because of the existing structure that was there, the canopy had already been elevated on that side. That's not really the point because the tree is located in the building footprint. And the building can't be shifted to the design exception. The height of the structure is not relevant to this proposal, except if it was reduced, it wouldn't accommodate the tree any better. And the third portion of this section, the internal flow and function is not adversely altered. Ms. Madhu's right in stressing that point. It is not adversely altered. We're stating it's a 30% reduction in the house that was proposed. Rooms and circulation are lost by preserving the root system provided. And in my opinion, that is an adverse alteration to the internal flow and function of that proposal. And that's all we have. That's all the code says in this section, 27-284, 2.5, footnote 5, I 1, 2, 3. That's all we can work from. And so I appreciate you offering the opportunity to kind of make that point.
Thank you very much. Councilman Miranda.
Thank you, Mr. Chairman. Mr. Federico, you're very competent in knowledge of trees and everything else, and I've taken always your testimony as the evidence of a professional, which you are. Councilor certainly represented by one of the highest attorney firms, Hill, Ward, and Henderson, and I've seen many of the Mobley homes built, and they're very, very good. However, after listening to all this testimony and listening to everything that I've heard, no one's mentioned that it might be a hardship on the house, but it was a hardship before the house was designed. You know why? Because it's a 50-foot lot. If it was a 60-foot lot, we wouldn't be here. Am I right?
That's probably true. Yes, there would be sufficient space on the lot.
So, and I'm pretty liberal a lot of things, but when we come up and we say it's a hardship, it is. Who created the hardship?
I don't know if I'm prepared to answer that.
I'm not asking you to prepare.
Okay.
Who created the hardship? I'm a criminologist. Who created the hardship?
Was it a lot of record?
Oh yeah, it's
Yes. So when was it platted?
1908.
I guess 1908. The developer then set this up.
Thank you, sir.
So, Councilman, thank you.
Thank you very much. All right. That concludes rebuttal. At this time, is there a motion, if there are no other questions, to close the public hearing?
I'll make a motion to close the public hearing.
Second.
We have a motion from Councilmember Hurtak, second from Councilmember Miranda. All in favor? Aye. What is the pleasure of council? We have three possible actions: affirm, remand, or overturn. Does anybody wish to make a motion at this time?
I move to affirm the VRB's decision to deny the variance requested in VRB 22-70 for the property located at 3122 West San Jose Street because the petition does not meet the criteria in section 27-284.2.5F4 to remove the grand tree.
We have a motion from Councilmember Carlson.
Second.
We have a second from Councilmember Miranda. Yes, sir. We have a second from Councilmember Miranda. Roll call vote, please.
Goods,
Yes.
Viera,
Yes.
Hurtak,
Yes.
Miranda,
Yes.
Citro, Carlson,
Yes.
and Maniscalco.
Yes.
Motion carried unanimously. Motion carried unanimously with Citro being absent at vote.
Thank you very much. That concludes our agenda. Mr. Shelby, since we start again at 5:01 PM, is there a motion to receive and file, or just we're in recess?
Oh, good.
I'll leave new business until tonight. So, it's, all right, can I get a motion to receive and file? We have a motion from Councilmember Good, second from Councilmember Miranda, all in favor?
Aye.
All right, we are in recess until, I'm sorry? Well, the meeting is 5:01, it may be a few minutes later. 5:01, thank you.